Good morning. I'd like to welcome everyone to the January 30, 2014 meeting of the Tennessee Board of Examiners for Land Surveyors. Okay, the first thing we'll do is call the meeting to order. And the second thing that we will do is we will adopt the agenda. I have been notified this morning that we need to make a few adjustments on the agenda before we approve it. One adjustment is we're going to move the applicant conferences from 1 p.m. today until after we read the public meeting statement, because we have a gentleman here to speak to us. So to accommodate him, we're going to take care of that. We will also address the other situation that's involved in applicant conferences at that time. Secondly, the item that says follow up on agenda items and sunshine law, that will be moved until 1 o'clock. We have someone coming to speak to us about that, and that's the time that they have available, so we'll move that. Additionally, we will add, after the legislative report, a line item for the TAPS representative to address the board with any issues or matters that they may have. It was inadvertently left off the agenda. Now, at this point in time, does any of the members have any other additions, changes, deletions, etc., to the agenda? I would like to add one item, if we could, for discussion. That item being to discuss possible continuing education credit for advisory board members. And we can add that item in the afternoon session today. If there's no other additions or corrections, the chair will accept a motion to approve the agenda as amended.
So moved.
Second.
And we have a second. All those in favor?
Aye.
Opposed? Okay. The agenda has been adopted as modified. Okay. This regularly scheduled board meeting is taking place in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the Land Surveyors Board website on January 17, 2014. Okay, we're now ready for business. So if you want to refer to your iPad for the first item of business, it'll be on page 65. I think the gentleman that is going to speak to us is Mr. Brotherton. Is that correct? Okay, Mr. Brotherton, if you'd like to come forward and address the board, please come to the podium. Thank you.
My name is Keith Brotherton, and I took the Tennessee State exam last October, and when I got my results to meet with you guys or put on the agenda to discuss a few matters with you.
Mr. Messier keeps the examinations for your edification, so no, sir, we do not have the exam in our possession. Yes, sir, we do.
Okay. Things that he mentioned that I've done wrong, there's a few specific that he mentions that I missed a part of a question related to writing a scope of work. feel I should go at least a 7. Number 7, he said miss some items need on a plat. I felt, I should at least got an 8. I mean, I'm not saying I'm perfect. What I can remember, I think I covered the base. Without looking at my exam, I couldn't. I mean, it's hard to discuss that.
It's apparent, and you've said it yourself up there that there were things missing on each of these questions, and I think really what you're contesting is did I really miss? In one example, you said 54%, or did I really only get 54%? Things like that. The fact is that it is a time test, and so you're stressed and you're limited by what you're capable of doing within that time limit. But that doesn't exempt the fact that if there are items needed on a plat by specifics that are set, that even if just one item is missing, it's in violation. A plat would be just one item. The things like that, and obviously there must have been some real point. I don't have in front of me. There must have been some real points missing on the boundary description to only receive 4.5 out of 12, and at the same time you only got 4 out of 8 based on the surveying contract, scope of work, things like that. The point is that obviously there were deficiencies in the answers. Otherwise, you would have received 100 on each of those. Not that anyone is perfect or is going to get everyone perfect, but there were deficiencies, obviously. One thing I really want to give you credit for, quite honestly, is coming here today and being assertive and being aggressive towards your licensure. First and foremost, you have really made a very good impression to me. I can't speak for the board, but for me personally, for you to make the effort to come here shows to me that you're willing to make those extra steps. While I can't change your score because it's your score on your exam, I would like to give you, all the credit in the world for stepping up and coming forward and being persistent. If I understood right, was this the 4th time on taking this exam? Is that right? Excuse me. Okay, 2nd time. My bad. Stick with it. Stick with it. Learn from this. You will. Obviously, you will. I can tell from the actions you're taking, your concern. You take this personally. You care about it, and that means a lot. The best thing I can say to you, Keith, is stick with it. If you haven't already, I hope that you have already signed up for the next one. Keep ahead of it. Be aggressive with it. Be persistent with it. You'll get there. You'll get there.
fill in. I was gonna bring you cookies and milk. Or what would you be looking for in the scope of work?
Frankly, I'm not sure, Keith, what Peter had on the exam and how it was worded or anything like that. We contract with him because he is an expert in doing just exactly what we ask him to do, and that is to design the test for the Tennessee state-specific things that we want. And I've known him for a long time, and his exams, I think, have always been more than fair. How he grades them, I don't take part in that. None of the board takes part in that. And the standards of care, whatever he's looking for, there must have been something in particular that you didn't have that he really thought was necessary. I don't know what that is. And, of course, on the other answers that you were saying, well, you got 4 out of 8 and what have you. But even if you may have gotten 75% of the question answered, maybe those things that he was looking for that you didn't have were more important than what the other things were. I don't know how he grades that. I don't ask him, and that's his business, and we contract with him to do that. And I did know what Jay said, because I really do appreciate your fortitude to come in here and stick with it. Be like a bulldog, be very tenacious, and don't turn loose of it, and just continue to do and go ahead. And if you have not already made application, go ahead and take this thing again. Do that. It's there. And you got that close. I wish I could answer more about how Peter grades, but that's his business, and we don't. Excuse me. We won't dabble in his business. He's the test maker and the test grader.
Well, Keith, I really don't have anything to add to what Jay and Galen have said. I echo their same sentiments. We'll review your application tomorrow, and hopefully we find in favor, and you'll be able to sit for the examination in April. And we hope that the one thing I would tell you is that Mr. Messier is only allowed so much latitude in communications with examinees, and he has basically provided you a pretty detailed analysis, short of exactly showing you exactly your answer and exactly how he marked it in whatever way to determine the exact number of points that you got or didn't get. Most states that I'm familiar with that have a proctor like Mr. Messier do not even go to this step. Basically, it's a very cold pass or fail, period. So, having the ability to have garnered the information that he has provided for you, I hope that you will do just what Jay and Galen said, that you'll dig in and you'll be much more successful the next time that you take the examination. I'm regretful that two things. One, the board does not have the exam in front of them. That is not part of the process that we have chose to do as a follow-up or review of Mr. Messier's work. And because of that, the board would be 100% unable to simply agree with you without having that or whatever, to basically just say, yes, you did pass it and we'll give you your license. Unfortunately, we can't do that with the process that we have. And we hope that you understand that, and I hope that you do continue your plight, because it's very obvious that you're very concerned. You want to become a licensee, and that's the kind of folks that we want, people that are concerned and passionate about it and will move forward. But we certainly want to thank you very, very much for your time.
I appreciate that. Well, thank you so much for your time.
Okay, Donna has informed me that Michael Burns called yesterday sometime and indicated that he had the flu and would not be in attendance today. However, I did ask, I feel like that we need to discuss this situation, whether he's in attendance or not. I understand he's going to try to attend in April, but the reason I would like to discuss this particular scenario is because I think, as you've all read, as I understand this, Mr. Burns' father was a licensee, and he passed away in April of last year. And as a licensee, he was providing continuing education, Mr. Burns, the father. Well, upon the father's passing, the son began to teach the course. And correct me if I'm wrong, Donna.
Yeah, he did. He didn't notify us until October that his father had passed away and he was teaching the classes. And he asked me, and I told him, it was inadvertently told him, but I told him that he could go ahead and teach the classes because they'd already been approved. I wasn't even thinking, that he wasn't a licensee or anything. Well, then some things came up where somebody called and reported him, and then that's when all this started.
So my concern is, first of all, let me say that an individual does not have to be a licensee to provide continuing education. Yet, by our procedure, they need to go the route of approval for their self as a speaker and their program that they intend to address. And I don't feel that Mr. Burns has done this, and the reason I wanted to discuss it today is if we wait until April and he has potential speaking times to give this continuing education, I'm concerned that we perpetuate a problem, potentially. And I'm certainly not alluding that he's not qualified. I have no idea. I've never been privileged to any data on Mr. Burns. So, that's why I wanted to go ahead and have discussion, even though he was not in attendance today.
I did tell him when he comes in April, he needs to bring applications of the courses he wants.
I'm somewhat concerned from a standpoint, and I direct this question to Rob. Would it be out of order to basically send him a letter and ask him not to present this program until he has met with this board and met the criteria that the board establishes for PDHs?
I think like everything else, you have to meet minimum qualifications before you embark on any activity that's even quasi-regulated. So I think if he's not qualified to provide the service, he should not do it until he obtains all the necessary approvals.
Well, my concern is if he takes initiative and continues to do this, it's affecting our licensees. Because John Doe is going to this seminar and going to get X number of PDH hours and then submit those, and Donna's basically not going to approve them because the program wasn't approved or the speaker, et cetera. That's my concern. And because as Donna said, I think that was the one with the Indian reservation, wasn't it? It was a strange situation. He had taught a course, and some surveyors on an Indian reservation or something of that nature had taken the course.
They wouldn't accept it.
And their chief, who was, what do you call himself? Something.
I don't remember.
Anyway, whoever, their leader, the leader of the tribal group there found this out and told his folks that, hey, look, these hours are no good. You're going to have to go take more, which they did. But I don't want to perpetuate that problem because, that costs somebody some additional money and time because, PDHs are not cheap per se.
Here's the issue that I have with it. It sounds to me like this gentleman was operating and conducting these classes under the impression that he had the authorization from this board.
Right.
And I think technically up to this point he still does without a letter that says from the board saying stop.
I've been getting courses from people and I've been taking them.
Sure. Yeah. And here's my point. Here's my point is I don't want to harm any of the licensees that have taken his classes with their understanding that they are approved by this board at the time they take that class. So what I'd like to do is if there is a letter to be issued from this board to this gentleman that's offering these classes, essentially a cease and desist order of some sort, that none of the licensees up until the date of that letter are affected.
Right.
I think
That's
that's
fair,
paramount.
yes, yes,
Paramount
yes.
is what I think, because it is an inaction or a misunderstanding on our part that these licensees took these classes under the impression that they were authorized.
I think the letter should probably, rather than a cease and desist, it should probably just say that the board won't accept any classes that he teaches. We can't really say stop because he's not a licensee.
Well, from this point, or whatever, like Jay's saying, from,
We're
you know,
just gonna
if
have
you
to
wrote, if you
inform
wrote the
him.
letter tomorrow, for example, from tomorrow forward, you know, until you've met with the board and met the board's criteria,
We
is that
won't
fair,
accept
Jay?
I think, yeah, I think
Yeah.
it's
I mean, that's kind of
absolutely
where I
what I'm
was
saying.
wanting to go. I didn't want to perpetuate the problem.
Exactly. If we put it off to April, then we're essentially authorizing that those classes are valid
Right.
up until April, and,
Right.
and that's not the case here. I think we need to stop this as quickly as we can. Unfortunately, there may be some harm to some licensees that are expecting to take a class, let's say next week, and then all of a sudden they get the red light that they get caught up in it. But that I think is while not to my likely, I don't like it, but I think it's unfortunate, but I think it's something that we have to do, is set a firm date from here on. If somebody is affected a week later, a month later, that they'll just have to find a way around
Let
it.
me ask this. We've already approved these courses, and we've set an expiration date, but can we change the expiration date to today?
I would say the date of the letter, or the date, if you send it by registered mail, the date that he receives the registered mail. And you could actually, could you include that, Rob, in the letter?
Yeah, and I was thinking, what about notification to licensees that these classes are not acceptable?
That would be up to him. That would
Yeah,
be up to
then
him.
on our
He's a
approved
proprietor
list.
offering these classes. He would have to make notice to people that are signing up for his classes that it's not authorized.
I don't know what we could do if he decides he doesn't want to do that. I mean, we kind of need to tell the licensees that this provider is not somebody you really need to utilize until they're approved.
Well, I think that if we write a letter, and however the letter's formed, and we do it with the proper registered mail receipt, once that registered mail receipt is received by the board, or back to you, whoever it comes
When
to,
I-
then
when I-
that's put on the website that,
They're
you know,
expired. See,
that
when-
these courses are expired or
Yeah.
whatever. I'm putting it right on the
Because they have
front
an
page of the website. And I mean, because that's became our number one, notification area, I
They
guess.
have an expiration, I give them an expiration date when they're approved. But if I change the, and then once they expire, they're highlighted and marked, those are expired. So if they come in and I get them and so if we expire his courses, they'll be highlighted in yellow that they're expired, put on the website.
Let me interject a couple of things here, because I've talked to Mr. Burns, and after he had talked to you, and he explained in detail what has already come out here, and I told him the same thing that Jay has been saying. Those people that have already taken these courses, even after his father had passed away, and he was continuing to teach that, there's no way, I don't think, that we could harm those guys and not give them credit for what they have taken. They took it in good faith. He may have taught the best class that has ever been taught as far as continuing education. I don't know that. But I told him, I said, you need to come before the board and let's talk about what you do from this point forward, because I said, if you are not qualified to teach the course, then we will understand and we will know that, and we'll tell you, no, you can't. If you are qualified, remake the application and the courses and let the advisory board go through and approve those things and give you a new date, and then he can continue to teach the courses. That's kind of the way I look at it. And I think that he needs to have a date to stop giving credit for these and refund the money until such time that he makes things right with the board as far as the time limit and the qualifications of the instructor and the appropriateness of the courses he's teaching.
People that have already been approved get to keep the hours.
Yes.
We're just sort of.
I don't see.
They would have to.
Yeah,
I don't think
I
we do
don't
anything
think we
else.
can do anything
Well, they'd
more
be
than
like
that.
bona fide purchasers.
Right, yeah.
Yeah.
They didn't know.
Well, it's not their fault that they didn't know, but we're gonna notify them now that there is a means that they would know after what we're talking about happens.
Yeah.
Reliance is what they call that. They didn't know, so they'd be harmed, and they were relying that this was something that they could use, and then they find out later it's not through no fault.
So do we set an expiration date of what's approved now?
How far down, how long are these courses approved as of the time that the gentleman passed away?
I think they expire in 2015, maybe February of 15.
Horses are we dealing with? We haven't even asked that question.
4? Is that what he said? I don't know.
Well, here's my point. I
I'm
don't
not
know,
sure they leave.
I don't know that we, and literally, I just don't know that we can change an expiration date after it's already been published and received by him. But rather, he is in violation based on the original application to offer these courses.
And I should
So
have told them to
already,
submit new ones.
the expiration is really,
Actually, it's already
is not
expired.
even,
When the provider passed
in
away, the course actually expired.
exactly
See,
right.
and this is the
Unless
first
he
time
was
this has ever happened, so I didn't even think about it.
So I don't know that changing an expiration date is the correct route to go. I think he's in violation already because the course he's offering is not based on the application that's on file here and approved.
So basically what you're saying is let's expire those courses because the provider is passed.
Was he helping his dad teach these courses?
I don't know. I don't know that.
It doesn't matter. It doesn't matter. If on the application it has the father's name and that's what it has on ink on paper,
And I agree with you.
the son, the wife, the daughter, it doesn't matter.
Yeah.
He was in violation upon the death of his father.
Agree with you.
And so it needs to stop right there. So I think, quite honestly, that as of whatever today's date is right here, assuming that the board approves that a letter needs to be issued, that on this date, he is to stop offering that course, period, until he reapplies.
I think that's the correct thing.
Okay, and that's his.
But doesn't she need to cancel those courses on the site?
I would definitely, information-wise, on the site itself, where it lists those courses, I would definitely highlight, asterisk, red line, something to the effect that say these are, in effect, expired as of the date of whatever letter we send out.
Right.
Absolutely.
Now, are you gonna send a letter out?
I think we're to the point for a motion, and I hear the spirit that it would be some type of letter or something of that nature. So Jay, would you like to make that motion?
Yeah, well, I'll form that in a motion that essentially a requesting a letter to be sent to this gentleman,
Mr. Burns.
Mr. Burns, thank you, saying that he must stop offering or teaching this course immediately, and that he needs to reapply if he intends to reoffer these courses.
Okay, we have a motion. Do we have a second?
I second it.
Okay, we have a motion and a second. Any further discussion?
Then those people that have already taken this course, they will obviously get credit, but the rest of the folks, if they have made application to take it but have not taken it, they should be notified by the vendor that this course is not available until such time as he makes reapplication with the board
And approve.
and approved.
That being a clarification or an amendment?
Let's just say clarification.
Clarification, okay.
Let's not amend the
Okay.
motion because the letter, the letter ought to include
Okay.
that kind of
Okay.
thing. We're just putting the letter together.
Okay, any further discussion? Okay, hearing none, I'll call for the question. All's in favor?
Aye.
Opposed? Okay, motion carries. Ms. Donna, you take care of that. Coordinate that with Mr. Rob, please. Okay, the next item is for the year of 2014, to officially adopt Robert's Rules of Order for our manner of operating. So, if no one has any problem with that, the chair will entertain a motion.
So moved.
And a second.
I second it.
Okay, we have a motion and a second. All's in favor?
Just a quick
Oh, I'm
question.
sorry, sir.
You said that's for all meetings for the entire year? We don't do this at each meeting, is that correct?
No, we do it once a year.
Just once a year, that's fine. I'm good.
Yes, sir. And for the board's edification, we will also be addressing some of this when the attorney comes and speaks to us at 1 o'clock today.
Good.
We'll
Thank
be able to ask any questions to that attorney and things of that nature about how we operate. Okay, if there's no further discussion, I'll call for the question. All's in favor?
Aye.
Opposed? Okay, motion carries. Okay. Next item on the agenda will be review and approve the October 2013 meeting minutes. Members have received those and have had an opportunity to read them. They're rather lengthy because we had all the hearings the last time. Yeah.
Mr. Chairman, if there's no changes or amendments to the meetings, I move we approve as printed.
Okay. We have a motion. Do we have a second?
I second it.
We have a second. Is there any further discussion on the minutes? Okay. All those in favor?
Aye.
Opposed? Okay. Okay, Mr. Herndon, your turn.
All right, I think it's page, what is it, 23, 25 of your pad. I'm just going to sort of summarize.
If I may, Mr. Herndon, interrupt you just a moment. It's been determined that Mr. Herndon does not have to read the legal report verbatim as he has in our past meetings. So we have them both in writing and on our iPads in front of us. And that's why that you'll find that Mr. Herndon is basically going to summarize. So if the board needs additional time to read or whatever, we'll certainly take that time. Thank you, Rob.
All right, the first three complaints all involve the same respondent, and briefly, this respondent was hired to do a boundary survey for a parcel that's sort of surrounded by three other parcels, three different complainants. They're all complaining basically about the same thing. This matter went to litigation to be settled in court. So the complaints are alleging that this person not only it's the easiest thing to say. There's really not a complaint about his competency, but there's a complaint that he may have had a conflict of interest and that some of the things that were statements that were made in court were misleading or untrue, which would violate the appropriate rules. All this was bundled up, sent to a complaint reviewer who reviewed it in great detail, including the transcripts from the court. This particular reviewer did not find any problems with anything the respondent did or said. So the recommendation is to close these cases for lack of disciplinary grounds.
Just to clarify, Rob, because we get brief information, apparently the respondent surveyed a piece of property and rendered an opinion by his boundary survey. And then three of the adjoiners complained that they didn't like where his opinion placed the boundary, basically.
Correct. They all
And then
three
it went to
took issue.
litigation.
Correct.
Okay.
So is it my understanding that three separate complaints were filed?
Yes, same
Essentially-
respondent. It's
essentially
the same
each-
matter, so I just bundled all three of them.
I got you.
So the findings of the court they didn't find against the respondent, or basically in the reviewer's readings of the court, he didn't find anything that alluded to a violation.
Correct. The court found in favor of the respondent's survey, which irritated, obviously, the three adjoiners, who then said that the statements that the respondent made in court were untrue or inaccurate, or you've probably seen this phenomenon before, and it's pretty classic. That's what it is.
I kind of think that the respondent in this case, that's why he has a license, to make a judgment call on what evidence he has found, and if he found it to be that way, and be it parole evidence or anything else that he might have found, physical evidence out there, and he made the call, regardless of whether the complainants agreed or disagreed with him, that was his call to make, and they went to court, and if the court's found in favor of him, frankly, I don't see it. I have to agree with your recommendation to close it.
Tough assignment for the respondent. But
Imagine there's 2 points on here from the summary here that stand out to me, and I'm just going to read it here. As to the first rule allegedly violated, the respondent proved to be completely objective and truthful in all professional reports, statements, and court testimony. And I'll continue on here. This was established by a review of the court transcript, which you mentioned. Second point here that stood out to me, a review of the materials relative to the second rule that was allegedly violated did not reveal any indication of a conflict of interest on the part of the respondent.
correct, and I guess the meaning behind that is that one of the complainants was trying to attach the respondent to one of the other complainants to show a conflict of interest, and there wasn't any. Comparison of the transcript with the work product and all that, our expert couldn't find any. It was pretty thoroughly reviewed.
Thought so.
Okay, is there any further discussion on this matter? The recommendation is to close the case for lack of disciplinary grounds. The chair will entertain a motion.
I move that we allow him to close the case.
Second?
Second.
Okay. Any further discussion? All those in favor?
Aye.
Opposed? Okay.
The one that's listed as number 4 is another boundary dispute. This one actually involved people putting up fences and all kinds of things like that. The respondent was hired to come in and do some work. The allegations here are breach of notice to landowners for finding any major discrepancies, and actually notice that you're actually coming on their property, and of course our law allows you to do that, but I think best practice is to actually notify somebody before you come onto their property, especially if there's a dispute over where the boundary line is. This went to another reviewer who took a look at the work product, and although there's not really a bright line violation, this particular respondent didn't really communicate very well with the parties involved. You need to send certified letters notifying of any discrepancy, and you certainly need to tell somebody when you're setting your corners across somebody's fence. So even though technically there's no competency violations, I think it was a little bit sloppy from what I was picking up. Could have been done better, so the recommendation is to issue a letter of warning and close the case, since competency wasn't involved, but practice among people probably could have been a lot better.
Since there apparently was no major discrepancy, even if you set corners across the fence, and I don't know the particulars on this, but if it's a subdivision lot and it went on the adjoiner's property, small distance, I say on less than a foot, a tenth or 2/10, something like that, I think that's probably standard practice among all of us if we're setting corners and that kind of thing. It only when it becomes a major discrepancy do we really need to notify the adjoiner. But being on the adjoiner's property, he should have taken enough care and what have you to at least notify them. And if they weren't there, our method of doing that is to send a certified letter to say, hey, I'm going to be surveying out here, and on this particular date, or at least I plan to, and I need to be over doing what I need to do on your property as well as on your neighbor that I'm working for. So,
In particular, if you're aware that this is a boundary dispute and it's a contested region,
absolutely.
the the adjoiner sees a crew that they didn't hire on their property.
Yep.
You probably should tell them while you're there.
Yeah, the point that really stands out to me is the fact that, in section 6218-124D, it does say, shall notify the affected adjoiners.
Mm-hmm.
I mean, there's no wiggle room in there. You
No.
shall notify, and if I understand the review correctly, he did not do that.
The rule probably should say notify in writing, because some people might say, well, I did notify them, but an oral notification is not sufficient.
You don't have evidence of an oral notification unless you have a witness standing there with you. So,
You won't have evidence of it unless you
Yeah.
have a witness.
so
The letter's hard to dispute.
that is.
And if you know that you're going into a war zone, you probably should have some kind of record that you communicated appropriately.
Additionally, I noticed that there was a second violation that the claimant mentioned, but it is not mentioned in the conclusion or the summary.
The expert didn't find that that was really relevant to the issue.
I see the recommendation there is to issue a letter of warning. Quite honestly, personally, I think it's taking it a little bit easy on him, but I'm good with that recommendation.
What would you do?
Well, if I remember right in a previous meeting, it was described there were certain levels of letters that could be issued.
Yeah.
That's the toughest letter,
This is the toughest letter?
unless you want to
good
label
with
it a letter of reprimand.
Okay, I'm fine with it.
After this level, you go to formal discipline, and I didn't know if you wanted to do that.
I agree with you, Jay.
Well, Jay, just so you know, just as a point, under civil penalties, a violation of this particular TCA is only $50 to $250.
Yeah.
That's all we could penalize if it was decided that a civil penalty was necessary.
Plus the time and effort of everyone involved in all that, including staff and ourselves and all that, so
That's correct. So I just wanted to follow up with that,
that's fine.
being somewhat limited as it may.
Yep.
I don't think you're reading that right.
Pardon me?
Hang on a minute.
Well, I may have the old one. I grabbed the old one.
Yeah. 124D.
50 to 1,000, is that what it is?
$1,000.
Yeah, 50 to $1,000.
Oh, okay. I apologize. I grabbed the blue book. It's too easy, and I know what page to turn to.
The blue book is easier and quicker,
I was wondering if it was the same.
Yeah. My fault. Sorry, Jay. I was trying.
I'm still good.
I
I'm still
stepped
good.
on the toes.
That's fine.
Okay. All right, I think we're ready for a motion.
I would move that we follow the recommendation to issue a letter of warning and close the case.
Second.
Further discussion? If not, all those in favor?
Aye.
Opposed?
Five. This one is, again, this is a dispute over inherited property among several heirs. The respondent, the land surveyor, apparently offended one of the complainants by saying that ownership of the property was in question. Well, and he says that this caused him to lose his timber contract. Well, the respondent, of course, for whatever reason, made that indication that the ownership is in question because the ownership's in question. It's in litigation to find out who owns what. So the statement was actually true, and of course truth is an absolute defense. So my recommendation was to close the case for lack of disciplinary grounds.
Sounds to me like it's more of a civil court issue. If he wanted to go that route, I really don't see any grounds here that we could take on that.
I agree.
Obviously, if they're in litigation to quiet the title, then the ownership's in question.
I would move that we follow the recommendation to close the case for lack of disciplinary grounds.
I second that.
Okay, we have a motion and a second. Any further discussion? All those in favor?
Aye.
Opposed?
Okay, number 6, once again, it's another boundary dispute. It turns out that, somebody died, and then it went to the decedent's heirs. The court decided division of the land that didn't really float with some of the heirs, so they filed a complaint saying that this particular surveyor didn't do this and didn't do that. The matter was sent to an expert to review, and of course, reviewing that court documentation, work product, the expert wasn't able to find any problems with his conduct. So the recommendation is to close the case for lack of disciplinary grounds. The respondent's really not responsible for how the court decides where the boundaries lie.
This case, as in the previous one, the courts
Very similar.
made a decision, and that's the way it is. And this board's not going to overturn anything that the courts have decided, so it's got to stay that way. And I agree with the recommendation to close the case. I make the motion to close the case for lack of grounds.
Second.
Okay, we have a motion and a second. Is there any further discussion? If not, I'll call for the question. All in favor? Opposed? Okay.
Is this a fairly common thing in the field, these types of problems? Seems to be.
I guess it is. I mean,
Common
all
thing.
of us have had owners that didn't agree with boundary lines and errors and et cetera, and you try to go in and straighten those things out. And
States are most difficult.
yes.
We do our due diligence whenever we get a complaint like this and have it thoroughly reviewed. If court documents are available, we obtain everything we can to make sure we thoroughly look at it. But it seems like.
Frankly, I'm not sure why a complaint would even be filed just because the court has already decided. Why are they going to come, to the board and complain about the surveyor when he put it on the ground the way the court said it should be or whatever it be? Because the surveyor can't help how the courts decide the thing.
Well, unless
probably
there's
the
some
hope-
other violation that
Well,
the
yeah.
court necessarily didn't address.
I think the
The
hope is
surveyor
if
could have done that.
if they can get an adverse decision by the board, they can take that back to court and say, see, this doing, and hopefully get a rehearing, I guess, is what they're thinking.
Good.
Or it could just be bald-faced
Yeah.
sour grapes.
Like you're gonna be on their property, you should. It's basically a courtesy by our, Law.
Somebody was
Yeah.
surveying next to us. He didn't contact me saying there.
I think it's like in these cases, if you know that there's a problem with the boundary and that's why you're there, you know somebody's gonna be watching to see if somebody shows up.
And if he got across the line, I'd have to report him to somebody.
We got two more, and they both deal with unlicensed conduct. So they didn't go to an expert because you're either licensed or you're not. The first case is about a respondent that's had a license in the misty distant past and it lapsed for a while. Then they came back, reapplied to get their license, which was approved. Unfortunately, they managed to stamp a plat a few days before their license became effective, which constitutes unlicensed practice. So they rolled the bones and didn't got a 2 there. So they did get their license, and there's no problem with their work product. So I recommend a letter of warning, close the case.
Am I right to understand that there is a document stamped and signed and dated November 14th, 2013 by this respondent? However, his license did not formally become valid until November 21st, a week later?
Over ambitious.
Yeah, I was optimistic.
Optimistic.
When reading the response letter and all, they pretty much admit that they didn't think that the office where you file it would get around to it. They did get around to it, so problem.
Well, I think, I'm not sure how this would sound, but a letter of warning said, well, don't stamp any more plats before you're licensed.
Yeah.
And so,
You just need to be careful about that.
I
I don't know what the rush
I don't know
was.
what the,
I think it's important for the board to note that this individual had previously been licensed. Therefore, they knew what the statutes were, and they had to know what the statutes were when they became relicensed. I just think that that's a point that the board should pay attention to.
Okay.
That's why it's a warning letter, not a caution letter. Because this person had a license a long time ago.
What kind of bothers me is kind of the brazen arrogance, to be honest with you. I read into it, there's a little bit of arrogance on this person's part, to be quite honest. And the fact that he was licensed before, so he knew the understanding. He understands, or should understand, the regulations in front of him. Obviously, he must have gone through the proper channels to reobtain his license, and thus accept all the responsibility that comes with it.
You want to assess a nominal civil penalty for formal discipline? then
Well,
that's
I'm
certainly
looking
an
at those
option.
penalties that are available to us under, is it 101B, $100 to $1,000, is that correct? That's where I'm seeing?
Yes, sir.
I would
only
not,
have one
I would not
instance.
be at issue personally to substantiate a penalty in this case, to be quite honest with you. I think a letter of warning certainly is adequate. Boy, that's tough.
What would a letter of warning be, since now he has a license? He's not gonna make that mistake anymore.
Can't provide any professional services unless you have a properly active license.
In the,
Got one
Slap on the
now.
wrist is what it is,
in
quite
the
honestly.
spirit of where you're going,
And the fact that he's been,
I would assume
Complaint
that,
before.
I would assume that if he had the ability to place a stamp on a document, he probably obtained financial gain from doing so equally.
That is a good point.
Certainly would be worse if the plat that he produced created some kind of problem. We don't know that.
maybe he just hadn't come to light yet.
He's already made a mistake.
Did you all hear what Sue said?
A civil penalty because he's already made the mistake. And a warning letter is, I don't think it's gonna do any good for this guy, because he's already made the mistake.
Yeah.
The next complaint is when you send that to me, you'd send out a warning letter.
Oh, what a difference a few days will make.
Yeah, really. It's interesting that the respondent, I'm just going to read here, the respondent states in reply that the submitted documents were not intended to be final. Well, I'm sorry, but if you put a stamp and a signature and a date on it, that's final.
Pretty final.
I didn't make a
That's pretty
comment
final.
about that, but from my experience in engineering, the engineer usually didn't stamp it and sign it and date it until it was, yeah.
If it's preliminary, you label on there, preliminary only.
Very not for
or
construction
review only.
over it.
And anticipate delete. Quite honestly, I think
I don't
a
know
letter
what-
of warning here is a little bit soft, to be quite honest with you, and I certainly would approve going after a civil penalty, to
I
be quite honest
agree.
with you.
If he stamps it and signs it, and that's not final, I don't know what a final document would look like.
Well, if I understand right here, the civil penalties that we're allowed to discuss here is between $100 and $1,000. Am I reading that correct? Make sure I got the
Per
latest version.
instance.
You have the latest version, I'm sorry.
Per instance.
Per instance, yeah, and I'm just seeing one instance here that I'm aware of, but I have no problem with a $1,000 penalty, to be quite honest with you. I mean, either we're serious or we're not. To me, $100 is not serious. To me, $1,000 means I'm serious. I don't want to see a stamp and a signature and a date on something that you don't hold a current valid license. Quite honestly, that's an insult to everyone who does.
The appropriate motion would be to approve for a formal hearing with authority to settle by consent order, just before you start making motions.
I would make that motion. Just like you said.
Make the motion.
That's the motion I just made then.
Well, if you can just articulate it.
Help me out there again with it.
Authorize for a formal hearing with authority to settle, giving authority to me to settle it for a $1,000 civil penalty.
Authorize for a formal hearing with authorization to settle for $1,000 is my motion.
That way I don't have to bring it back or anything. If he declines the settlement offer, then we can go right to a formal and I don't have to represent it.
All right. Motion made.
We have a motion, do we have a second?
Second.
Okay. All's in favor?
Aye.
Opposed? Okay.
Another problem with boundaries. The thing is, the complainant found out that the licensed owner of the firm used a unlicensed draftsperson to prepare some drawings. And it turned out that no final documents were ever produced. This was a company that bought some land adjoining to the complainant. And of course, the company wanted to have an easement. They couldn't get to their property. They wanted an easement so they could get in there and start, I guess, logging is what they were going to do. So they hired the respondent to come in there and tell me where I can get an easement. Well, the respondent says you probably need to talk to the landowner. But I'll prepare you a preliminary plat showing you where an easement could go. Contact the complainant, never hear anything back. So the company says, I would like you to go ahead and prepare a plat that shows an easement. And I wasn't able to determine why, but at that point the respondent said, here's your preliminary documents and I'm not going to do anything else for you. And that's as far as it got. So the complainant says, well, the respondent produced a plat and it caused me all kinds of trouble and this and that, and it was prepared by an unlicensed person and so on. But really it was just a preliminary document, never was stamped or used for any other purpose other than to show his client, the purchaser, where an easement might go. So my recommendation is to close the case for lack of disciplinary grounds.
I have two complainants. I see it's got two separate case numbers.
One is the licensed owner,
Okay.
one is the unlicensed draftsperson.
Okay, so no signed, stamped, dated plat was ever produced? No certification made that it was under the supervision of a licensed surveyor, nothing to that effect? Just
Nothing that could be filed to establish any rights. Just preliminary stuff. Matter of fact, I think the respondent did the right thing by saying you need to work with the landowner that's in between you and your land to see if you can find an easement, but that never worked out. So probably why the respondent said, here's your preliminary documents, I'm not going to do any more for you.
I really don't see where we could go with this. I don't know
I don't
if there's any teeth in there or not. Tim, you got anything on it?
No, sir.
All right.
I agree with you.
All right. I'll make a motion to follow the recommendation of close the case for lack of disciplinary grounds.
second that.
Further discussion? If not, I'll call for the question. All those
Aye.
in favor?
Aye.
Opposed? Okay.
Alrighty, that's it for the legal report.
Okay, that concludes the legal report. It's now about 5:10. If the members would like, we'll take a short break, and, because we have a lady coming to speak with us at 10:30.
Members would like.
Okay? So Donna, if you'll turn us off for just a minute, we'll take a little break. Come back. Okay, it is now 10:27 a.m., and I'll call the meeting back to order. I understand we have a guest to speak with us on the legislative report, and that's Ms. Greer Kelly. Did I say that correct?
Yes, sir. Thank you.
Thank you very much for coming to speak to us, and we're all ears.
Okay. Well, thank you so much for having me this morning. Like I said, I'd heard a lot of good things about this board and was excited to come and talk to you this morning. I'm a legislative liaison here at Commerce and Insurance and have been here almost 2 months now. So a little green, but it's very exciting. Land surveyors have 3 bills in the legislature right now. The first is, do you all have, if you don't have copies of the amendment, they're all available online at the Tennessee General Assembly website.
Page 31 of your pad.
Excellent.
Oh, yeah.
The first bill is Senate Bill 2375, and that was just filed last week, so it has not been assigned to committee. But it amends Title 66, and the basic idea is that land surveyors would be required to review property descriptions before the title is transferred and attest to the quality of that description. The idea is to limit the liability for the reviewing land surveyor. And then the following 2 amendments are relatively are very similar to one another. Senate Bill 2300, sponsored by Senator McNally, and Senate Bill 1931 House Bill 2234, sponsored by Yeager. Both of these amend Title 62, and it would exempt applicants from exam and degree requirements if they could provide evidence that they have at least 10 years of supervised practical training under a licensed professional. The only difference in the McNally bill and the Yeager bill is the Yeager bill requires a notarized affidavit by the supervisor. We believe it is the intent of the sponsor to sunset this rule within the next year. So I think they would have 4 years to take this test, and eventually that will no longer. The people that currently have 10 years have a certain window of time to take this test, but it will no longer be an option after that. And then the suggested amendatory language would require applicants to complete the exam, whereas the way the bill is currently written, they would not have to complete the degree requirements or take the exam. Can I take any questions? Concerns?
Yes, ma'am. First of all, from my take of what I had read of the bills, I certainly missed the statement you made about the exam not being a part of the equation. I
Right.
certainly missed that.
Missed that as well.
So I appreciate you bringing that to our attention.
Okay.
That really concerns.
I guess the first question that I might have, and I'm sure each of the members may have questions for you, is
Okay.
we, as a board, have received a letter from a representative, Susan Lynn, maybe? Is that correct?
I believe that's right.
I believe that's correct.
Believe I've seen
Pardon me,
that,
I'm not
yeah.
real good with names.
That's
I'll probably
okay.
mess yours up in a minute. But the letter was directed to each member of the board individually. I guess the board would seek your direction as to how not only this letter or speaking to other either senators or representatives would be appropriate from the board, because everyone, with the exception of our public member, Ms. Sue, we are all licensees, so we are stakeholders in legislation relative to our license. So not only would we have necessarily a personal opinion about the matter, we would likely have a board opinion about the matter. So I guess that we're seeking direction from you as to how we should proceed. If a response one is in order, and if it is, how do we do it and do
Okay.
it correctly?
Okay. That is a good question, and I might defer to Rachel on some of these. Do you have a particular issue with some of the legislation that I mentioned?
Well, I would
Yes.
have to, initially, I would have to speak personally because
Personally,
the board has not crafted a stance
Okay. Okay.
collectively. So to answer your question, from a personal basis, as a registrant, yes, ma'am, I have issues with the legislation.
Okay.
You know, my real question is, and this is following up on what Tim was saying there, is should the board, can the board formulate an opinion on this bill, whether it's a we support or we don't support, whether it's as dry as that? And if we can, as a board, formulate something like that, can we then also express that to these individual legislators in a form of a letter? And, you know, with title head, Board of Examiners, to that effect? Does the board have the ability to express opinions on legislation to the legislators themselves directly?
I mean, I think that's absolutely within your right as citizens and as organizations. I'm not a lawyer, so I will defer maybe to a lawyer, legal. So I want to defer and make sure that I'm telling you the right thing. But I think as a department, we will likely defer on these issues.
The board can certainly take a position on it. It's just a matter, what I was interested in knowing is how you want to express that, certainly in a letter, but to see how that needs to travel through the department if it does. I'm not familiar with that procedure. And that might be a Rachel question.
My name's Rachel Powers. I'm the Program and Policy Director for Regulatory Boards. It's very nice to meet you all. Rob, can you repeat defer as to?
I guess the question is, if the board wanted to have an opinion on legislation and wanted to put that in a letter, what would happen to the letter?
The board can absolutely put their opinion. It just has to be voted on and agreed on as to the opinion. So that being said, you all know that, as you said, you voicing your personal opinions, you'd have to do that on a personal basis. You wouldn't be able to do it on behalf of the board. But you can absolutely say, we want to say this about the legislation and put it in a letter and send it to the speakers if that's what you choose to do. But this is very early on in legislative session, just so you all know. Bills that are filed this week, next week, and the next week, because the bill filing deadline isn't until February the 5th, could drastically change before the end of the session. So just know that before you take any definitive action, that things are always subject to change, especially when they're filed early on.
Well, one problem that we have with that, and I thank you for that information, is the fact that we will not meet again until early April. So I guess from my standpoint as chair, if we need to craft something, we probably should craft it now, and not, in other words, not be coming in late in the game, I guess would be fair to say, after this legislation has molded, shaped, or whatever. Even if it went away, would we be in error if the legislation just totally went away to formulate an opinion?
I think that's up to the board to make that decision.
Uh-huh.
And just to echo, I was actually going to make the same point that Rachel did, that it will very likely change over the course of the next couple weeks. And, I think there's two bills that I mentioned that will likely be merged into one. And I can certainly keep you in the loop as things evolve. And you all, I don't know if you can take a position, if you can do things electronically or some sort of communication aside.
I guess
from
that would be a
meeting.
question for Ms. Nicole. Let's assume that we conclude this meeting and do not formulate a position to forward a letter or some document to legislatures, plural, and the bill is reshaped, recrafted, as these young ladies have indicated, and that happens in the next 2-3 weeks or whatever, and then the bill begins its normal process of where it goes and who looks at it and so forth. How would this board, short of having a called meeting, have the ability to formulate that? Well, my concern here is obviously I think that a letter from the Board of Examiners would carry much more weight than a letter from Tim Lingerfeld. Or it should.
I think where he's going with this is can, in this public forum, can we authorize the board to issue a letter? However, the exact content of it has to be formulated, obviously, outside of the public venue that we're here now, because there just isn't time to sit here and literally physically type up a letter. Obviously, we're not scheduled to meet again until after the deadline that was mentioned. So is that something that we could do in the public venue, say, yes, the board is going to express an opinion to the legislatures on specific Senate bills, and that would be adequate public notice, and then until that deadline comes, we can formulate and issue the letter? Am I saying that right, Tim?
Yes,
Is
sir.
that kind of where
Yes,
you're going?
sir.
I just wanted-
Generally, the process for this in the past has been that the board will ask legal counsel to draft a letter that says what they vote. We support this, we don't support that, or we think this is great, but maybe add or change. That being said, you can do that. Lots of boards take legislation, follow it. They meet more often than April. And Rob would craft a letter for you all and bring it at the next meeting, and if you voted to approve that letter, it would then be sent. That being said, Mr. Lingerfeld's concerns is that something needs to be done now. You could vote on the record, and that's public on the record. Sometimes legislators reach out to boards to comment on bills and that sort of thing. That hasn't been done here. Like Greer said, things are possibly subject to change because it's early on. we say that, you have to take that as we say. It could stay the same all the way through and pass exactly as is. So just know that. That being said, these things all touch a lot of the same things and are intricately different, just little pieces of them. And one has already been filed and withdrawn. So, I think it really has to be a board vote decision on how you have to do it. I don't think that you can say, we have an opinion and we'll formulate the letter later. I think Rob would have to get the board to approve whatever he writes.
I think you should probably craft a letter that says something like, as currently written, the board takes the following position on this bill.
Well, my concern, Rachel, was not that we necessarily had to do it immediately, but within the confines of the meeting, because if I understand correctly, and Nicole can correct me, that if we have a call meeting, we still have to have a 30-day notice, do we not?
We don't have to have 30 days notice. What's the public meeting requirement?
If in today's discussion, if we authorized Robert to issue a letter to the legislatures that is, either in support of XYZ bills or not in support of XYZ bills, would that be adequate right there? And then after the meeting is closed, he can formulate it essentially the way. I mean, is that adequate public notice? I mean, does the public need to see the actual content of the letter?
The letter becomes a public record.
It'll become public record anyway. So I would think that if the board were together today, be able to authorize a letter either in support or not in support of specific bills, that would be adequate notice that we're authorizing a bill with the content of what is be. I would think that's got to be adequate.
Vote on the board's position. The actual verbatim language doesn't have to be voted on.
Well, I would write the letter and then submit it for the chairman's signature.
Sure. All right, I did have one question here. Greer, maybe you can answer this for me. And this is just from lack of knowledge. The two Senate bills are awfully similar. I mean, to the point where it's like they had to have been in cahoots with each other about this language. I mean, the language is almost identical. What is the advantage to having really the same bill submitted twice? Is that a strategic move on their part? Is it literally left hand not knowing what the right hand's doing? Because
I
they're
think
awfully similar.
I know. I think your guess is probably as good as mine here. I would go with the latter. I think there was a lot of chatter about this, and then my guess is that Yeager's was first, and then
What?
McNally.
That's right.
That it was just a matter of being discussed a lot, and then he filed it because they are very, very similar. And I have picked through them both, trying to see what I was missing. But more than likely, they certainly won't both be passed.
Okay.
Can I deviate while I have this question on my mind so I don't
Sure.
forget? Going to a different venue, what ability does the board have to, I guess I would say, suggest legislation? In other words, for example, I'll give you a very good example, practical example that we're going to discuss later on today. We're discussing the possibility of licensing photogrammetrists as land surveyors, okay? But currently, there's not anything in our law that allows that, which would require some legislation. My question is, if in our discussions we found favorableness in that, then legislation would need to be obviously implemented, crafted, whatever, to do that. What abilities do we have as a board to be involved in that on the opposite side of the process from what we just talked about?
In crafting legislation?
Yes.
Well, that's a good question, and I'm sitting here thinking about how a lot of things come about at the legislature, and typically there is a very similar and somewhat different stance between the industry and the department. And there are some things that I actually want to check with with my supervisor on to see in what ways we can represent your interests when we're over at the legislature and talking to senators and representatives. I think a lot of times when we take a position, it's defer with amendment, so with some sort of amendatory language. And I don't know if that amendatory language is something that we could discuss with you all and change these bills in a way that works for the board. I think you all could certainly, you could find a sponsor in the House and the Senate and have your own legislation drafted, excuse me.
Well, again, my direction here on this, and I know I've deviated from when we started, and
It's
I
okay.
apologize, but this thought was on my mind, was I sometimes feel like that the board should be proactive in a matter of that nature, and formulate some opinion about it. And if it's favorable, then I think the board clearly can reach out, for example, to the association, the professional association, and seek their approval also, and maybe that they will step up. The professional association might step up. But what I was trying to get to was whether or not the board itself had the ability to do the same thing.
Okay. I think that you make a great point, and I'm probably going to go back to the original suggestion, is that you all could vote on something that would be public record and then have your association lobby on behalf of the industry, and you all are certainly welcome to take a stance. I don't know if it's something that you want to get into working on legislation and sending letters. And do you think that you agree with that statement?
Yeah, the board itself can't carry a bill. It would be the professional society that would carry it, because it wouldn't be a departmental bill, something like that.
But I guess the direction I was going on, Mr. Hernan, was if we sort of, I guess, foster the concept, I guess would be fair, and come to some conclusion or direction about that concept, then we could have the ability to move that forward. I guess that's what I'm trying to get at is I don't feel it's appropriate for us to have to wait on the association to foster the concept and then start the process that we're in with this other scenario.
Well, the fact that the profession that you're talking about is not a regulated profession, I think it would be better that anything that was pursued would be done as individual members of the profession within the professional society. The board can't really opine about an unregulated profession that's not within their jurisdiction. So I don't think a board opinion is really helpful or useful. It almost entirely have to go through something that was identified in the profession that they see as something that might need to be regulated. I mean, the board's just not set up to regulate something like that. It's nowhere in the law, and
Right, I certainly don't want to take a steering wheel and drive legislation, by no means.
no.
I have enough trouble understanding it.
It's just sort of a non sequitur. It doesn't have anything to do currently with land surveying. So if it was discussed within the forum of the professional society and they collectively determined, and you as members of the professional society pitched in, not as board members, I think that would be far more effective, because the society would be the one that identified the need for it. They're the people on the ground doing this stuff, and they've seen a need.
Best course of action as well as for you as individuals to foster the idea within your professional association.
Again, that was more of a need-to-know
Yeah.
question scenario, so I better knew, how to approach that, and I appreciate that.
Legislative concerns or questions about?
So routinely in the future, will you, if there is something like this on the Hill, will we be able to see you at our meetings?
Absolutely. And I know that you're not meeting again until April, so I would be more than happy if I can have a business card, and I'm going to leave mine, but I will, whenever I see land surveyor legislation, I'd be happy to loop you in, send you a copy, or just a notification that you can go and look at it. All have business cards. I'd be happy to do that.
I don't have my email on mine.
probably do now after we take care of this is that go through these bills and see what the board feels about them. If you want to give me some kind of direction, is to write a letter, which would be, of course, be subjected to me drafting it and submitting it to the chairman for signature.
Would it be possible to put that for tomorrow?
Well, I was sort of going that way because our liaison is here at the moment, but
I can take your opinion back to when we are forming our opinion.
just
I
so
mean,
she
it's
can hear what you had to say, and it would be.
I don't know exactly how much weight that would carry, but it's always nice to have the board thinks this.
If you just want to tell me how you feel about it, then we can come back to it tomorrow. But I just sort of wanted to hear it while she was here.
All right. Well, I'll speak to 1931 and 2300, being that they're very similar
Okay.
in content. My opinion on it is I am not in favor of it, to be quite honest with you. I think the current rules and regulations as they stand today are adequate and sufficient. I'm aware that, and I was a part of when the original four-year degree education came through. It was certainly endorsed strongly endorsed by the professional association, as I was a part of it during that time. And so certainly they endorsed it as it was submitted. In addition, I've looked at the surrounding states to see what their requirements are in terms of an experience-only route. And most of the states, or many of the states that surround us, will not even consider an experience only. And of the ones that do, many of them are combined in there with some level of education to be combined with it. And there's one or two that do allow an experience only, but one of them was Missouri, I believe, was 20 years of experience only, if I recall correctly, as opposed to what these bills are offering of 10. If I remember correctly, Mississippi, I think, was 12. And then there were some educational requirements or classes on top of that, not necessarily degrees, but things like that. But as a whole, from my research, if you look at what these bills are offering in relation to each of the surrounding states of Tennessee, which is a good barometer to judge against, if these were passed as written as they are today, Tennessee would have the weakest requirements in terms of qualification for examination, and I don't think I want to be a part of that. I don't think I want to be a part of that. I don't know how that serves the public in a positive way, or supporting the public, and protecting them for the quality of the surveyor that comes through. And so as written today, I can't endorse, personally, I can't endorse either of those two Senate bills. Speaking on 2375, that was the property description. I like the way it's written. I do believe that is also endorsed, if not sponsored, by TAPS. I can't speak for TAPS right now, but I do believe it was. I have heard some discussion on it. I've seen preliminary draft copies of what those reports would look like, and I do support that one.
Okay.
Well, like Jay, and I have to agree totally with what Jay has said, but I too was on the committee, and I was the president of TAPS when we pushed for the legislation that asked for the degree avenue toward licensure. And I think likewise that to do anything different, to offer education, the experience level right now would certainly weaken our avenue toward licensure, and is in no way in the best interest of the public in the state of Tennessee. I just fail to see that. In addition to that, we are trying to work with the major universities to see that surveying programs courses are taught in the major universities. I'll tell you that this last week we met with the University of Tennessee in Knoxville just to go over their programs to see that they could offer the programs, not just have to go to one university and get a surveying and surveying and mapping degree, but just get the surveying courses so that they would be educated enough to take the exam. And so it's a very positive meeting with that. So I think that the avenues toward education are about to be broadened in this state, which would make it easier for an individual to become licensed.
reading it, I agree with them about the experience, that you don't have to have as much experience to,
As far as 1931 and 2300, I'm very firmly opposed. I will not reiterate the reasons that they've already said in the interest of time. However, I will say that I sit on the Examination for Professional Surveyors Committee with the National Council of Surveyors. And that committee crafts the examinations. And those examinations are made up of primarily the first two parts, or the first 14 hours, basically, of what an individual is required to pass to get to the state-specific examinations to be licensed in any individual jurisdiction. Those examinations are formulated and crafted around the Bachelor of Science degree. Because of that, they are quite difficult. And the thing that sticks paramount in my mind is that difficulty makes it much more challenging for the individual that does not have the degree. Create a scenario of potential multiple examinations and things of that nature, which in some way creates a hardship on the board and its administration of such. But also the experience route in today's technological and advanced society somewhat, in my mind, does not support the public as well as it should. However, having said that, it was a huge hurdle when the BS degree became part of licensure for surveying. Surveying, since I began, primarily has been known as a trade and not a profession. Surveyors that worked hard to get the BS degree, to give us an equivalency level to other professions such as the legal profession Mr. Herndon's in, engineers, architects, doctors, so forth and so on. Surveyors have worked very, very hard to elevate their foundation for the profession. And that's my concern, is that if a bill of either one of these natures is approved, we regress. And I do not want to see our profession regress. We have struggled long and hard, and I have said many times that I hope by the time that I retire that truly every licensee in the state of Tennessee will be known as a professional. That's my whole goal. That's one of the reasons I wanted to be on this board, to help try to foster that. And try to do, not only in my personal business, but in the other endeavors that I'm involved with. So that's my reasoning behind not being in favor of this legislation, because I do not want to see us regress, even if it is somewhat limited by sunset. As far as 2375, it's an interesting concept. It brings about good potential, and it also has significant value to the public. I've read it, I've went through the forums and so forth on it, and as far as that goes, I'm in favor of that.
I could just make 3 points just real quick. I'm going to make them brief because I know your time is valuable. Again, I can't speak for the board here but myself, but I think they'll concur with me. I certainly mean no disrespect in any way to any surveyor right now who obtained licensure through the experience route. All right, I've worked with on a daily basis people that have come that way. I respect them as professionals, so I don't mean to say anything disparaging against people that have gone that route. There's nothing against it whatsoever. Second thing, if my numbers are correct, I believe it's approximately 30 states right now already have recently, and I say recently within 10, 15 years, mandated the 4-year degree requirement. So that Tennessee is just one of those of the many states that's doing it. I forgot my third point now. It was a good point too. I can't remember what it was. remember.
Senior
Well,
moment.
it's a senior moment coming to you.
You
It's a
get
good point, too. I can't remember it. Anyway, we'll just leave it with 2 then. I'm sure once
Okay.
you walk out the door, I'll remember it, but.
No, it's okay. Do you?
Yeah, my name is Len Tusar. I'm the TAPS, Tennessee Association of Professional Surveyors, a representative to come to these meetings. There is a House bill by Caffey. Did you have that also? Which is the companion bill to 20,
Jaeger, I believe, isn't it?
to the Jaeger bill? Okay.
Yes, sir.
So that, when they're talking about that, they're also talking about this. And there were a couple other bills that have come through that will really affect surveyors. One has to do with family cemeteries, another has to do with the review by county planning departments that would affect plats that were submitted for approval by county register. There's a whole bunch of legislation right now that are going to affect surveyors, so, I mean, just so everybody's aware.
Okay. Well, thank you actually for pointing that out to me because I'm not a land surveyor. And so I think there's some legislation that comes through that I maybe didn't realize the impact on surveyors. And there will be legislation that is introduced between now and February the 5th that I know that we expect a few more things in the pipeline. And I think your concerns are very valid in terms of the experience route. I just probably to shoot straight with you and to think about just what what the other side of the argument is sort of on trend with these experience apprenticeship models in terms of job creation, and they're doing it in a lot of industries. Talking about it in Cosmo yesterday, but I think that you all have a very, very valid point and argument, and you can talk about the Haslam's administration, looking at higher education, and so I wish you luck.
Let me do one other thing, too. Leonard is the TAPS representative because he was appointed by TAPS, but we're privileged to have here with us the current president of TAPS, Jimmy Cleveland. I'd like for Jimmy to step up here and have a seat and just have some comment
Okay,
to
I would
give to you
very much
also.
appreciate that. Thank you.
Jimmy said it's very quiet and nobody ever notices him, so.
Thank you again. I am Jimmy Cleveland, the current TAPS president for 2014. TAPS has got, much I hate to say it, we got a divided membership over this. This is an issue that, with the utmost respect for these gentlemen here who are members of our association, we've got our members, like I said, our membership's just divided on it. I personally, speaking as the association, we are in favor of the sunset law to only affect those that have applied and been denied application because of the confusion of the way the current law is written. But we're as an association are in favor of the sunset law, limiting that to the people that have applied and been denied due to the confusion of that law. Now, taking my TAPS hat off and speaking personally as as a member of the association and not as a president, I got to say I personally don't support it because the law has been in effect as we are bound to understand the law if we're in that profession, and these people should have done their due diligence and researched that. And I'm one of the guys that came through with a 2-year associate's degree and a 6 years experience, and I gotta echo what Mr. Lingerfeld said. It's an extremely difficult exam, and had I had to take it today geared around a 4-year bachelor's degree, it'd be extremely difficult. So I think it may be setting some people up for the experience route. It may be setting them up for some disappointment, and to spend a lot of money to pursue that licensure and maybe not be able to pass it just because the way the examinations are geared now. So it's I'm personally torn on it again because as the president, when I have that hat on, I have to represent the stance of the association, and as the president of the association, all this came about extremely quickly within about 3 days, actually probably about 2 days before our last regularly scheduled board meeting, is when this came to light. And I don't want to say it was a knee-jerk reaction of the letter that we submitted to Representative Carr, but in that letter, which I'd be happy to share with you, we do reserve the right to change our opinion after we've had a chance to speak with our general membership. So, very, very touchy subject, and I can honestly say I don't think that anybody here, or any, and Leonard, please chime in, I don't think anybody in our association would favor the concept of no examination at all. That's absolutely a no-go for me or the association, as far as I can stand today and say that. So that's kind of where TAP stands on it at this point.
Thank you. I very much appreciate all of your opinions. Please let me know if there's in any way that we can help or work with you all as we move forward in the legislature. I'm gonna leave my business cards for all of you and hopefully take a few so that I can continue to keep you in the loop.
Kelly, we'd like to thank you very much for coming today.
Thank you.
And listening to our concerns and providing us with the information relative to the legislative side of things. I think that'll make us a very much more productive board, so that we do not, I guess, say waste time on things that we shouldn't address. And I really appreciate that very, very much.
Well, thank you. Best of luck going forward.
Look forward to having you back at future meetings.
I will. Thank you very much.
Yes, ma'am. Thank you. Okay, so let's stay in that spirit. Is there anything, Mr. Herndon, that we need to further formulate, direct, relative to this letter that you're going to prepare?
I think Mr. Kaufman wanted to kick it to tomorrow, didn't you?
Well, that was before we were going to express our opinions here individually. But now that we've done so, I think we can probably do it now.
I think you've already got your feet wet, right, Jay?
I jumped in the pool. I can't get dry.
So let's just, what I would like to do is just take it one at a time.
Sure.
Senate Bill 1931 is the version that removes everything, education, exam, everything. So if the board would like to make a motion to support or oppose.
Make that motion to oppose Senate Bill 1931.
I second that motion.
Any discussion? Call for the question. All in favor?
Aye.
Opposed? Okay.
Senate Bill 2300 is a version of the bill that strips the education requirement but leaves the exam requirement.
Motion that that this board opposes Senate Bill 2300.
I second that one also.
Any further discussion? All those in favor?
Aye.
Opposed?
I guess we can say Senate Bill 2375, which was the attestation statute. I think everybody was for that. I think it came from TAPS, or somebody theorized that it did. Do you have that one?
Make a motion that I am in favor of Senate Bill 2375.
I second that because I'm in favor of that too.
Okay, we have a second. Now, is there any discussion? My question is it necessary for us to speak in favor, because by speaking in favor, it gives it more weight or merit?
Certainly, yeah. I think the advantage to addressing a letter in favor of this does just exactly what you're saying, gives credibility and enforces the full weight of this board behind that legislation, and can only be a positive thing towards its passage.
Further discussion? If not,
I would
I'm
like to
sorry,
make,
I'm sorry.
let's go ahead and make that, take that vote right there.
Okay, if there's no further discussion, we'll call for the vote. All those in favor?
Aye.
Opposed? Okay.
One quick question I have real quick before these letters get addressed. it's been mentioned that, and history certainly shows that these bills will change. They'll be amended 2, 3, 4, 10 times over, might be withdrawn, who knows? Whole sorts, different things that could happen. Being that those things may happen, the opinion of the board may change.
I would say that the letters say as written.
Thank
The
you.
board opposes
Date as
legislation
written.
as written.
With a date to whatever it is. Yeah, thank you. That's what I want to make sure.
Now, if somebody would like to make a motion to authorize me to write a letter, perhaps give a board member authority to finalize that version.
Let me ask a question, and that's exactly where Leonard's going. We have a House bill that's a parallel bill to probably 2300.
Yes, it is.
Should we not include
Or-
that because
no, I'm sorry.
we have knowledge of it today?
Yeah, it's 1931 is the companion bill.
Oh, I'm
to it.
sorry, thank you.
House Bill 1931,
No, it's House Bill 2234,
2234.
which is word for word.
Yeah, it's just
And it was by Representative Kelfi.
okay. The Senate Bill 23.
Didn't as of yesterday.
It didn't as of yesterday, when I printed these stuff up.
Nor did 2375.
So the letter would address Senate Bill 1931, House Bill 2234.
Separate one then.
Separate letter. And you don't really have to write a letter to support 2375 unless you just want to. It's on the record.
I'd like to.
I think it's worth it. I think
Okay.
that probably would lend even more credibility to the fact that we are opposing the other two.
In that spirit, Rob, Mr. Tussar also mentioned a couple of other bills. I don't know if we need to speak to those or not.
Well,
at
the
this
ones,
point
the
in
ones
time.
that were on consideration on the agenda are just the ones that were talked about just now. I haven't seen those. These I've seen because they came through our office and I had to do a bill analysis on them. I haven't seen those other ones that you're talking about, so I don't even know what they do. So I don't really care.
You'll like one of them, I know. Because it'll certainly hit the practitioner right between the eyes when he goes out and sees something that's been done. I'll make the motion then that we ask our legal counsel, Rob Hernan, to draft the
I'd certainly like the opportunity to review that before it goes out. Second that?
Okay.
Second that motion.
We have a motion and seconds. Any further discussion? If not, all's in favor?
Aye.
Opposed? Okay.
I'll draft a letter and send the draft to the board members to look at. Get a final version, I'll prepare one for the chairman's signature.
Other legislative issues at the moment? If not, the next item on the agenda was TAPS. I know the TAPS gentlemen have spoken. If there's any other thing that you need to bring before the board, it's kind of your time. It's your nickel, Leonard.
Well, I would like to give a report and let you know that the TAPS Board of Directors met on January 18th here in Nashville. There were several things that were on the agenda. One of the things we discussed was about issuing a statement to the Board of Examiners about TAPS supporting a sunset rule for the affected applicants who applied recently to sit for the examination based on experience only, and were denied because of the the fact that experience only is not an acceptable method to sit for an examination, by statute, and that if for some reason this legislature were to go through and extend this or whatever, that to allow people that had applied to sit for the exam, then that we would allow it to make it along individuals to reapply and pass the LS exam for for up to 4 years, okay? No longer. I mean, we discussed different times and figured that those people that had applied, this was certainly more than generous time for them to reapply and sit for the exam and successfully pass it. That was one of the things we had discussed, so. And, of course, we're going to have our annual conference this year in Murfreesboro, and we set it up to be again next year in Murfreesboro. And we also discussed the property description legislation that you guys referenced before, and that was done as an action item. And they also discussed some getting additional surveying courses in other locations in the state, be it UT or Tennessee Tech. But that's my report.
Thank you. I'd like to just point out two things, if I may. One, going back to this legislation, not to beat a dead horse, I think it's important that in the presentation of that legislation, that it speak to in-state residents. Just so that TAPS knows, we also deny out-of-state individuals that apply in that regard. And to follow up on that, just for edification, the reason the 10-year language was put in the law was because, let's give you an example, and I can't think of a state right off that doesn't require the BS, but I'll pick any state, it doesn't matter. Let's say Iowa. I'm just going to pick them. They're the whipping boy for this discussion. If you were licensed in Iowa, and Iowa did not require a BS degree, and you came to Tennessee to apply for licensure in Tennessee, the Tennessee board had to have some means to evaluate your license as to say that it was comparable to the requirements in the state of Tennessee, okay? So the 10-year was put in place because the language in that subparagraph C specifically says practice surveying, which by definition in our statute means you are licensed. So if you had practiced surveying in Iowa as a licensee in this example for 10 years, then this board felt like, by statute, that you were equivalent to the other requirements that we had simply because your state did not require a BS degree when you became licensed. So that's really the definition of the 10 years.
Yeah,
so
yeah.
I think those are two
Oh,
very
yeah.
valuable points.
Oh, yeah, yeah.
That, if your membership further discusses it, those are things that they should be aware of.
Rain?
Yeah. Oh, yeah.
That's what it is.
I was shaking the wind a bit in it or something, shaking something. We got a drum, we get a little beat with that and make something out of it. Okay. But I did want to indicate those two things. And thank you very much for your report, Mr. Tussar. We greatly appreciate that. Oh, one other thing I would ask. Since our board has been asked to present a roundtable discussion, I think on Saturday, is it 11:30, Jimmy?
I believe so. That's gonna, the roundtable with the Board of Examiners will round out that'll be the last item on the agenda, and then they'll do the infamous ATV drawing after that.
Okay. So they'll either not want to hear very much from us or whatever.
March the 21st.
22nd, and I'm pretty sure it's 11:30. I have not seen the published thing yet because I don't think
Just
it's
got
been
mine
sent out
yesterday.
yet.
I just got mine yesterday.
Okay, I haven't got mine. It may be at home when I get back.
I can tell you real quick. Hopefully.
Okay.
There was one question, and I think, I guess this would be the appropriate time to ask, or I know one thing that has, of course, as everybody knows with that legislation, and as I indicated earlier, I have to represent the current board of directors' opinion, and that's what I was charged to do today. That's why I preface those statements, whether I got my TAPS hat on or my personal opinion. But in that, there was one thing that was brought up, and one was the confusion that we've all talked about over that 10 years and the wording and things like that. But one thing that was brought up was, under board policy number 9, any person who's practiced land surveying is defined by Tennessee Code annotated 6218-102, subparagraph C, I believe, under a legitimate exemption such as employment by an agency of the federal government not requiring a state license to provide land surveying services and having attained at least 10 years of experience of a standard satisfactory to the board in such a capacity are eligible to apply for registration under this provision. I know that appeared to strike some of the people with a little, I don't want to say favoritism, but I know that was one thing that was brought up in that meeting.
Well,
That was a question that was raised.
okay, I know the answer, but I'm gonna let Mr. Herndon answer it.
A restatement of that.
Board policy 9, you want me to reread the board policy, or do you want me to reread?
Writing some of the letters that
Oh,
I
I'm
was
sorry.
asked to write.
Sorry to interrupt you. Okay.
That was crafting some language.
It's the part concerning the federal employees, Rob, on the 10-year situation.
Yeah.
That just appeared to strike some of the board of directors a little, I guess, in the wrong way. That somebody, just because they were a federal or state employee, so they work for state parks and commissions or whatever the case may be, retracing boundaries under a licensed surveyor, that
Well-
they could apply. It seemed like it was an unfair advantage being a state employee or a federal employee.
Well, the reason that's in there is because, of course, the federal government trumps our licensing statutes. And if you are hired by the federal government and your job description is land surveyor, and your job is identical or very similar to what a licensee would be doing, and you can prove that you've been doing that for 10 years, of course, it has to be acceptable to the board. But that would be practicing because you're doing it and you're not required to have a license because you're working for the federal government. And that's why that's in there.
I believe it's similar in many other states. There's very similar statute in other states that I've seen.
It's really the only exemption that exists for this board to where you can actually be a surveyor without having a license in this state, is if you're working for TVA or the Corps of Engineers. But your job has to be land surveyor, and the duties of that job have to be what the board would consider being a land surveyor. If you've done that for 10 years, then you have legitimately practiced and been a land surveyor for the feds. You may take the exam. Does that make sense?
It doesn't issue or say that you can be issued a license. It just says they're capable to
You can
take the
apply,
exam.
yes.
Apply.
It just means you're eligible to apply to
Yeah.
take the exam.
I mean, that,
I think
And it has to be a specific job too.
Yes.
You can't just be in their civil department. Well, I helped do this and that. It has to be, that's your job. That's what you were hired to do. I don't even know if jobs like that exist. I guess they do.
Federal service. That's a really very, I would think, a somewhat limited pool. But as Rob said, the federal laws trump ours. Our hands are really tight on that one. So we can't preclude them. It's just like, in a way that's very similar to
Another jurisdiction.
an individual being in the military and being, overseas in Afghanistan for a year or whatever, There's certain concessions made because of their service to the country.
There's other professions like engineering and maybe accountancy and some other jobs that we regulate that you can have with the federal government. And they're, you're an engineer for the federal government, but you don't have a stamp from Tennessee. But you could reciprocity your way in by virtue of being an actual real engineer just with the feds.
Going back to the roundtable,
I've got it here on Dropboxes. Dropbox is my friend. 11:40 to 12:30 on Saturday is the roundtable with the Board of Examiners.
is there anything specific that the association wants the board to speak at?
We have-
far
we
and
have-
away from the 10-year, because I don't think that would be very
That-
appropriate.
Well,
Maybe argumentative.
as I've indicated to you, I'm not sure whether Andrew or myself will introduce you, one or both, but I imagine both of us will probably be handling mics for you that day. We've requested that any questions directed to the board be submitted in writing, and that, and I think as I indicated to you, we're gonna request that everybody understand and respect the fact that there will be certain things that the board can speak on and certain things that the board may not be at liberty to speak on. And remember that professionals and adults and let's conduct ourselves as such. I don't want it to be, I mean, last year's roundtable, I believe it was last year, turned out to be a great thing, and I want to make sure that this one, even with the hot topics that seem to be surfacing, I want to make sure that this one is just as civil and informative.
Question, does that roundtable serve as a formal board meeting, just like we're here today?
Yes.
It does,
Sort of
okay.
meeting, yes.
Under the same rules and everything,
Yes.
okay, that's what I
Yep.
thought,
Yep.
making sure.
Noticed meeting.
So
of the
it's
board.
videotaped and all that, okay.
No, it's not
No, it won't be
videotaped. I'll take
videotaped.
minutes.
No, we have someone taking
The
minutes.
minutes are taken,
Yeah.
okay.
Time again on that, Jimmy, 11:30 to 12:40?
11:40 to 12:30.
11:40 to 12:40.
Yes, sir.
Second.
That's what I said.
That's what he said. Will you be in attendance, Rob? Probably?
I wasn't there last year.
Okay.
I probably won't.
Okay, are you going to attend, Miss Nicole? Okay. I guess you're going to ride herd on Sunday, okay,
That's a good time to put that, because everybody be ready to get out for lunch.
yeah,
Well,
Get that
everybody
from
want to know the final winner of the ATV.
yeah.
Yeah, right, okay.
That concludes the TAPS
I
report.
believe so. Mr.
Made
Linfield.
Leonard mad and he left, I think. Okay.
He had to change the heart, he came back.
All right. Miss Donna, I noticed that Mr. Dennis brought in lunch, and I'm gonna give you the floor if you wanna start your director's report and do it. And then we can eat after your report or whatever your pleasure, because that would be the last item in the morning session.
We can
Okay,
go ahead and
so-
do it. It won't take
All
long.
right, jump right in there.
All right, I just wanted to keep y'all abreast of where the rules are that we had the rulemaking hearings on. The professional conduct rules are in the AG's office, Attorney General's office. The continuing education rules are waiting to go to the AG's office. We're still working on those. Also, the board needs to vote on who to send to the NCAAS Southern Zone meeting in Charleston in April.
Before we address that issue of who attends, what have we learned from the Assistant Commissioner's office relative to whether or not this board would be able to accept NCAA funds?
Follow up on that, and as long as we have a contract with NCAAS, which we do.
Having said that, then, that means we can send two, hopefully still send two members, as we have been sending. I don't think anyone's corrected us on that just yet. So, having said that, I would like to recommend, of course, I can't make the motion, but I'd like to recommend that Jay and Galen attend. I also am going to attend, however, I will pay for my trip myself. But I'd like to recommend that you guys go. Motion, vote on that.
I've been to one of them, and I've been to the national meeting, two of those, and I'll tell you, goes into forming the exams and the process it goes through. Just don't understand, and we talk about this legislation that's before our legislature and experience. When you see what goes on and how this exam is designed and what have you, are the it's an eye-opening experience, and I'm very appreciative of. Certainly go.
Well, it sounds like an outstanding opportunity, and I'll just go ahead and make that motion that that allows myself and Galen to attend.
Okay, do we have a second? Any further discussion? All those in favor? Opposed? Okay.
Is that for the Southern Zone meeting? or
Southern
for-
Zone meeting in Charleston, yes, April 24th.
So it's not for the
26th.
annual meeting?
No, we'll vote on that in April.
Okay.
It's in Seattle this year.
Okay, the next thing is some continuing education for y'all to review. The advisory committee reviewed it. There's 3 courses. They reviewed it, and they both came back with different numbers. One would say 2, one would say 4, or one would say, you know.
Okay.
So I don't know how many hours to give these courses.
Did all the members receive the package that had this information in it relative to the courses that Donna's referring to?
Yeah.
Okay. And then we'll address this also once we complete this item. We have recommendations from Bart Craddy and Mike Roberts relative to these courses as submitted. It appears that, for the most part, they've agreed on all the courses and the number of hours for the courses, with the exception of 3 courses. Those 3 courses are Opus Solutions, State Plane Coordinate Manipulation, and Spiral Curves. Opus Solutions, Bart recommends 2 hours, and Mike recommends 3. So if you want to, we'll handle these one at a time. Have I guess, a motion relative to how many hours we should award.
Well, I did review the literature that was provided in regard to that specific one, the Opus Solutions. I'm somewhat familiar, having used
one is
Opus and the process involved.
That's a renewal.
Is it renewal?
Yep.
What is the, I guess it's already under the current PDHs that are allowed?
4.
4. Mhm. And the recommendations are 3 and
3 and 2.
3 and 2. Well, the fact that that previously, and I assume the course has not changed any. Same course, just up for pre-pro. Okay. Wow. Yeah, it's kind of unusual then if it's the same course to be approved.
Well, it doesn't mean that
For a
Bart and
renewal.
Mike approved it before either,
Well, that's true. I'm sure that's what it was.
because we've kind of had a moving group on our board.
Yep. Well, assuming that it is the same course, same content, same time involved, I'd be inclined, quite honestly, to just keep it at 4, to be honest with you. But being that the recommendation from our advisors here are 3 or 2, I would suggest 3.
I would agree with 3, because I reviewed that. But,
Have a preference, Ms. Sue? Okay. My take was 2, but the chair will entertain a motion.
I move 3 PDHs for the Opus Solutions.
Do we have a second?
Second.
Any further discussion? If not, all's in favor? Aye. So Opus Solutions, Ms. Donna, will be 3 PDHs. Okay, the next one is State Plane Coordinate Manipulation. Bart says 4 and Mike says 6, and they requested 8.
Is this a renewal?
I think so.
What was it originally?
8.
Yes, that's renewal also.
It
They
was
was originally
originally 8.
given 8 hours.
I think again, I think I would give the maximum of what has been recommended by Mike. I'm not sure the rationale behind each of those guys' thinking, but I tend to think that
Six.
6.
Yeah, I would agree with that, 6.
Okay, do we have a motion?
So make that motion.
Okay, a second?
Second.
Okay, any further discussion? All those in favor?
Aye.
Opposed? Okay. State plane coordinates will be 6 hours, Ms. Donna. Now, we have one more, gentlemen. Spiral curves. Mike Roberts says 4 hours. Bart says 6, and it was originally 8. So we're back where in the same
This is a new
shoe.
one.
Huh?
This is a new one.
Oh, this is a new one. Oh, okay. All right, Jay, you're at liberty now. Have
We're on now.
You're on now.
The collar is off.
Jump right in
Cut
there,
the
Jay.
leash. Yeah, again, I did get a chance to review the documentation that was provided. It's an excellent topic. Quite honestly, it's one that is unusual in terms of not many people cover it, other than maybe a quick class that's covered for one day at most. To be honest with you, in my experience, it's an important topic, and I feel that it should be covered. I tend to favor the recommendation of the 6 hours. I believe it was. Bart with the 6. That would be my recommendation of 6.
I agree with Jay. I will go along with the maximum on that of 6 hours. for
Okay. Do we have a motion?
I'll move 6.
Second. All's in favor?
Aye.
Opposed? Okay. The answer is 6, Ms. Donna.
Okay, and our next thing and last thing is the board members need to vote on the new continuing education advisory committee member.
Excellent. I'm glad that's a topic of discussion here. I was asked by the chairman to find someone from the West Tennessee district that would be not only worthy, certainly, but certainly capable of a pretty awesome responsibility of reviewing these applications for continuing education. And once he asked me to do that, I really didn't have a second thought. I knew exactly who I wanted. Mr. Byron Harris, a longtime registered land surveyor, has served the Shelby County area for many, many years. Currently owns his own business. His son is also a licensed surveyor. He has several licensed surveyors under him. And he recently, and I say recently, within the last couple of years, I believe, has officially retired his license. Byron, I'm speaking of. But he has always, and from day one when I was surveying the Tennessee area, he has always been a very active person towards continuing the quality of surveying. He is an outstanding, not only outstanding surveyor in my opinion, but even more so an outstanding person. And I think he would be more than worthy of this responsibility. I think he'll take it very seriously, as he does all of his surveying responsibilities. And I have contacted him. I have asked him if he'd be interested in serving in this capacity, and he did say yes. And so with that, I'd like to submit his name for consideration.
Second for that?
I second that because I read through everything that Jay sent concerning his desire to.
Okay, we have a motion and a second. Any discussion? All those in favor?
Aye.
Ms. Donna, if you can get Mr. Harris's information from Jay if need be, and would send him at least an email and thank him for his willingness to serve on this committee, and tell him how much we appreciate that, and we look forward to him being on the committee and being a valuable contributing member. Also notify Bart and Mike Roberts, so they now know that they got somebody else to help them with these things, and this should help the load a little bit. Okay.
And that, I'm done.
I would like to add one thing at the end of Donna's that's in the same spirit of where we're just at on continuing education advisory board members. I had a lengthy conversation with Mike Roberts the other day. Primarily, we were talking about some of these courses and so forth, and he brought up a very valuable point. They spend a pretty significant amount of time reviewing these courses and determining the value of them to our licensees. And I think that's a very important job. And as Galen has spoke about it before, we do not compensate these individuals in any manner financially. Yet I discussed that with Mike, and Mike brought something up to my attention that I felt was very worthy of discussion by this board. That being the possibility of this board giving continuing education credit to these individuals for the work that they're doing. And I certainly thought it was a very valuable question. and point. So I wanted to throw that out to you all and see what you all thought about it. I mean, I realize that they're not taking the course, sitting there taking that course, whether it be 2 hours or 4 hours or 6, whatever that course value may be. Yet, in many cases, such as a good example, the Lucas scenario that we all went through in an email here just recently, Mike brought that up and said, well, I read virtually every one of these in order to determine the merit of it. And he said, I did get value out of reading these. And, but I'm not getting any course credit out of it because I'm not taking the exam or whatever. So I felt like that his point was very well taken. And maybe if you all deem fit, it may be appropriate to do something for those members because as all of us on the board have known, especially Sue, she's been on a little longer than the rest of us, it's been a real task to keep advisory board members. And, if we have some way of, I guess you would say, compensating or thanking them for what they do, I think it would be good if we were able to do that.
Yeah, I'm not disagreeing you in the least bit there. I absolutely think they're certainly worthy of being awarded PDHs for exactly what they're doing there. My only question, I grabbed the book here from Galen. My only question really was, is there a category in there already that they fall under, that's already in here by code? And then also, on the flip side of that question is, can we award PDHs if it's not regulated by code already? That would be my only question. I'm not questioning whether they're worthy of it in any fashion. I absolutely think that they do. I just wondered if they already are covered here and could just put that on their reporting form.
I hadn't thought of that. I think it's a valid thing that they be awarded some kind of remuneration for what they're doing, but
I don't know. This would be probably to Robert. Would we have if it's not specifically or covered under code as it is already, would we have the authority to do that if it's not by statute to begin with?
Only thing I see on the advisory committee, and Robert, you'll probably have to correct me on this, but is 0820-5-15, where it says y'all may appoint an advisory committee to assist the board in evaluating continuing education programs to determine the allowable credit to be awarded.
Well, I think that, Jay, in the spirit of where you're going, under 0820-5-.05, it says, paragraph 2, the board shall grant credit for only such continuing education activities that satisfy the following criteria. Under A, it says clear purpose and objectivity of activity. Now, moving forward in that same section, under paragraph 5, it says all activities submitted to the board for continuing education credit are subject to approval by the board. Therefore, if we feel that activity is meritorious of continuing education and we approve it, then we fall underneath that particular portion of the rule.
Sure. I just want to make
In
sure
my
we're.
opinion.
Yeah,
Now, Rob may
I want to make sure
correct
we're
me
still under
there.
the rule. I have no problem with that whatsoever.
Now, I felt like that we were well under the rules in order to do what I threw out, or I wouldn't have thrown it out.
Can I offer an
Yes, sir.
opinion? Just from a registry standpoint, I would think that could fall very similar to the discussion we had at the rulemaking hearings about unapproved or courses that we talked about for out-of-state members that were not pre-approved. I think I've spoken with several friends that have served on that committee, and that's a labor of love right there.
It
And I
is.
think they are very, very, worthy of whatever you got.
I know Andrew and Paul in particular would have appreciated some PDHs out of their work.
But they
for
would.
sure.
It's a lot of time.
For sure.
I think.
Yes, ma'am.
For approval of continuing education, I think, and I don't have the copy of the continuing education section that you just worked on. Section under 820-5.05 types of acceptable continuing education. You have the part under 4 other activities which can be approved by the board. That's, I think, the part that you'd have to consider. It would have to be pretty specific, and it would have to be authorship of published papers, articles, or books. They would have to request credit for it, and it would have to fall under a certain category, although I'm sure that it's worthy of it, and I've certainly done professional work in my own license. Have to apply for it and get it, and it has to fall under the rules under a specific category. Evaluated under this section of the rules for it to apply.
Oh, certainly would not imply whatsoever that they would not have to fill out the form and things of this nature. I'm just simply saying that let's just reach out in the air and pick a number. If it was 8 hours, for example, just to pick a number totally out of the air, I have no direction towards that, then they would still need to fill out the form, but they would fill out the form just as we do for our board PDHs. They would fill out the form that said, advisory committee, review of courses, et cetera, 8 hours. In other words, what I'm suggesting is that we establish a quantity of hours that they would be able to obtain, being on the committee for the full calendar year, doing their review and their work. That's what I would suggest. And they would still have to submit appropriately and so forth.
I think probably ought to also.
I don't think the current rule wasn't written, it was written with the intention of people taking classes or teaching classes.
Right.
That's what it's written around. And I can't remember right off, but we proposed modifications in when we rewrote the chapter, service on, didn't we put something in there about service on boards and?
Oh, yeah.
I think so, yeah.
That would easily fit into that,
Certainly would.
under the new rule, when it's effective.
It says active participation in professional and technical societies, 2 PDHs. That was what we put in under the new continuing education at our last meeting.
Service on the board. Else on there about any kind of other service to the state?
We discussed that, and I think that we pulled that, because we had looked about the officer, official position type situation, and we pulled that. When we had our discussion on that before. I didn't bring those notes with me, but that's what my recollection.
Well, it kind of sounds like, I'm sorry, I mean to cut you off. Go ahead, Nicole.
I apologize. I think it needs to be worked on, but it can take a while before those implementations go into effect.
No, I don't think that was what the suggestion was.
Yeah, it's kind of like stamping a plat before your license.
Won't do that.
Although it might fall under those rules, I know that things can get bogged down in the Attorney General's office, and I would hate to make promises we can't keep.
How about if we do this? I think, how about if we walk away with either a yay or nay as to whether we would like to approve PDHs for their efforts, but at the same time, we need to do some homework on it, and if we could get probably an opinion from Robert really to see that if yes, it falls under the current guidelines, it's allowed, you can go ahead and do it, or maybe it doesn't, and sorry guys, but we tried. I mean, otherwise, we're going to sit here and spin this thing around and nobody knows the answer.
I don't have no problem with that.
So,
You okay with that?
I'm
All right
okay with that.
So, Rob, we'll leave that as a task for your attention for our next meeting. How's that?
Action item.
It's an action item, basically. Just let us know if we can do it, and if we can, we would certainly like to.
Absolutely.
I think that's the spirit of the board, that we definitely like to do that. Okay. Okey-doke. Anything else? If not, Ms. Donna, you can turn us off, and we will adjourn for lunch. It's now 11:48, so I understand we have an attorney coming at 1 p.m. to speak to us, so we've got a good hour to enjoy our lunch.
Yeah, be fine.
Okay, I'd like to welcome everybody back from lunch. It's now 1 p.m., Thursday, January 30, 2014. We have two gentlemen here with us. Want to make a presentation for us?
Sam Payne, our, what's your title?
I'm the Deputy General Counsel over the Rec.
Very nice to have you gentlemen here, and I'll turn the floor over to you.
Thank you. I'll be brief. I'm not positive whether I've met this group before. I've been in my position. Bob, who's kind of down in the trenches working with you guys day to day.
As Sam said, we presume that y'all have some pretty good working idea of this presentation, however, is going to assume, simply for the sake of argument, that when we're done here today, we can all be on the same page, and if there have been any misconceptions that have crept in over time, that we can dispel those. And Bob can or Sam can, any questions you might have when we're done. I promise I will not keep you here for more than about 3.5 hours. Okay. We'll go ahead and get started then. We call it the Sunshine Law. The Sunshine Law really comprises two laws. The Open Records Act, which deals with public records, Freedom of Information Act requests, you keeping proper minutes of your other is the Public Meetings Act, and that's really where we're going to spend the bulk of our time today. But briefly, what's included in open records? Pretty much everything. Public records or state records means all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing files and output, films, sound recordings, and if that's not exhaustive enough, all other material, regardless of physical form or characteristics, made or received, etc., etc. And obviously of the legislature is very clear. If you write it down, it's game. It needs to be kept properly, and it's probably going to be subject to your Freedom of Information Act requests and things of that nature. That's all I'm going to say about that. That is largely, as you know, an administrative function. Your staff. I wanted to give you just sort of a bird's eye view of it so that hopefully you can be equipped then to say, well, if I have a question about that, that's where I can go. Let's move into the bulk of it and what we're really, what is really the larger item of concern for you all today, and that's the Public Meetings Act. And what is it? It's really going to cover three broad questions. What is a meeting? And then by extension, what a meeting is not. And so we're going to try and put some bounds around this so that you can get a good idea of where the boundaries are. Once you find out that you have a meeting in that more official sense of the word, what are you required to do? There's 3 or 4 things up there. Notice, that's really going to take care of most of it. Folks, once you get down meetings and notice, 80 or 90% of the work, and the rest of it is, as far as you're concerned, is mostly details that we'll just... agenda, you can kind of mentally put a question mark next to agenda. We'll talk about that more as we get into it. Public presence is a big one. And that's really what we're trying to accomplish here. And then the minutes of the meetings. Again, I'm not going to say anything else about minutes. That's once more an administration. Those questions for you about that. And then finally, the remedy. If you either individually in your capacity as board members or collectively as a board or as a committee or subcommittee, if you violate the Public Meetings Act or the Sunshine Laws generally, the courts, if God forbid you get sued over it, is going to be nullity. It's as though what you did never happened. And that's a real problem. If you have a ne'er-do-well licensee who's deliberately miscalibrating all of his equipment or something, phone calls between one member's house and another member's house, and that's not out in the sunshine, it will be as though it never happened. And so that bad actor would still be left out there, doing what you had been trying to that you're here to do. So nullity can be a problem. The other thing is that once you get into a situation where your acts are being significantly questioned, it's going to raise a red flag for everything that comes after. Serious drag on your ability to do your job. Here's the first part of the statute. The General Assembly, Tennessee Legislature, it's a policy of the state that any formation of public policy, and that's going to be your rules, your regulations, your adoption of new rules and regs, modification or amendment of old ones, deletion of ones that no longer serve your purpose, that's public. Vacations and so on. All of that is public business, can't be conducted in secret. Laws of the Tennessee Constitution, it says that, look, we can't read or free speech as individual American citizens or really citizens. So we're not saying that you can't say what you need to say. What we are saying is that whatever you say, more or less has to be on the record, okay? And so that's a good way to think about that intersection. Act is remedial. That is legalese for we can't fix a problem until after it's happened. And as a result, we're going to construe the act as broadly as possible. As we go forward, we're going to see a lot of language that includes all and every, and you better believe it, and you're darn tootin'. And to protect the public against closed-door meetings at every stage of a government body's deliberation. All meetings of any government body are declared to be public meetings open to the public at all times, except as provided by the Constitution. And you see, aha, there's my way out. Not really. That exception is a very narrow exception covering executive sessions, and we'll talk about that more. What you should take away from this part of it, though, is the breadth of the language, and we're going to see this over and over again, that every time the legislature speaks, they always use the broadest possible language. The intent here is to close any possible loopholes and to eliminate any doubt in anybody's mind whether or not something is covered under the Sunshine Laws. It absolutely applies to the Land Surveyors Board. You said, well, it's any act or any meeting of a governing body. So what's a governing body? Pretty much any public body with two or more people. Well, if you're at home thinking about board business by yourself and talking out loud to the bathroom mirror, that's not. Everything else is. Any body that has any authority to make decisions or recommendations. And we'll move on and we'll see, excuse me, past, there was a problem where folks said, well, only the full plenary board makes decisions. Everything else is just deliberation or debate, committee, subcommittee, and that doesn't have to be. That all does. What's a meeting? A meeting is any time you get together and you need a quorum in order to do anything. That's pretty much going to be all-inclusive. What's not a meeting then? And here's where we can try to put some shape on this. A meeting does not include inspections. So if a complaint comes in and it's determined that there needs to be an investigator out either to a job site or to a firm office, that's not going to be a meeting that has to be open to the public, and we can see that. It's unwieldy real fast if you have to give notice to the public and make sure the public knows where to show up every. What else is not a meeting? A meeting is not a chance meeting of 2 or more members of a public body. No such chance meetings or informal assemblages can be used to decide or deliberate public business. This is a real spirit of the law kind of a clause. There's a case down there I've cited, Aiken. I promise I won't do this more than once or twice. I won't. There were some residents of some previously unincorporated county land, and the town of Kingston Springs got together and decided they were going to annex those folks, and they didn't tell them about it. And what they did was they made the vote to say, hey, we're going to annex you folks, and that vote was in public. It was all noticed properly. It was a good, clean, sunshine law meeting. However, before that, they discussed the precise bounds of the land that they were going to annex, and they did those discussions behind closed doors in secret, and the court said, nope, that's bad, that's a violation. Whole annexation. And as you can imagine, that would not a place you want to be to have your official acts unwound. Here's an opinion from the Tennessee Attorney General. You can share a meal together in which public business is conducted, but discussion should not constitute deliberations. So if you want to sit here and have some more cake or have a sandwich while you're doing your meetings, great, fine. But if you're not on the record and if the public can't see you doing it, and these all come from either Attorney General's opinions or court cases or things of that nature here in the state of Tennessee. Lunch breaks, restroom breaks, smoke breaks. If you have a morning and afternoon session and you take a break for lunch, take a recess, or if you have a multi-day meeting and you adjourn overnight. Those aren't meetings. But what are we getting to? If they're not meetings, you can't talk about board business because the public doesn't have the opportunity to be there. It picks up regular meetings and special meetings. And it's not up here, but emergency meetings. If you notice, you ever have to have an emergency meeting, it's still that you have to schedule it because you still have to give notice to the public for them to show up. The only exception there is your executive session. So let's talk about that briefly. There are 3 very specific circumstances in which you might look to say, this is an executive session and we can do it behind closed doors without public participation or public attendance. When one or more of you goes to meet with your board attorney, the illustrious and inimitable Mr. Herndon, and the board has either been sued or is about to be sued. Somebody told you that you're no good and they're going to sue you. And when you are asking questions about the law or about the legal implications of your actions of your attorney. Okay? So if you say, gosh, we're about to take action X, and if we do so, give us sound legal advice as to what the consequences of that are gonna be. That's fine, that's an executive session. If he says, well, blah, 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 and then you say, well, based on that sound legal advice, I think we should do X, Y, and Z. No, now you've crossed the line. That's debate or deliberation. By the way, if that executive session where you're seeking sound legal advice starts to turn into deliberation, your attorney is bound to put the kibosh. Deliberate about any specific matter that's before you or any potential matter that could be before you. You know, I think this might come up in the future. I've seen a news article on this, and gosh, this is going to be real problematic for us. That's potential business and should be on the record. Extent of how absolutely far this goes. There was a excuse me. There was a case here where the Civil Service Board in Maury County was interviewing folks for jobs at the Sheriff's Department. And they weren't the folks that were going to get hired. They were interviewing folks to vet them to go on the list from which the Sheriff's Department could be hired, right? So it's the first step of at least a two-step hiring process. And the Attorney General says that because these people could potentially be hired by the Sheriff's Department, and because the public has such a strong interest in how those people are going to behave and deal with the public, those interviews fall under the Sunshine Law and have to be conducted on the record. That's carrying it a little bit far, but that's where we are. So a few examples. If one of you emails your chairman and said, here's a news article that I found that's pertinent to what we're doing, fine. And by the way, I'd like to talk about it and have it included on the next agenda. That's fine. But by the way, here's a news item about one of our licensees who's a big dirty rat and we need to revoke his license. Now you have offered your opinion as though it were part of a debate or a deliberation. And that is where the line is crossed and there's now a violation of the Sunshine Law. And this also is going to cover faxes and text messages and your board attorney says, well, I have a question about the legal consequences of something the board has done or something I've done in my capacity. I've taken an action and now somebody's upset. And what we need to remember is that your attorney is the board's attorney, your individual lawyer, and is probably all right. If you undertake to communicate electronically with another board member, just really stay away from it. If you call one another and say, hey, I'm sorry that my kid beat up your honor student, or gee, there's going to be a great potluck at the church this Wednesday night. Perfectly innocent, but it raises a giant red flag. And the first thing that the courts and the public and it was a perfectly innocent discussion. The first thing that folks are going to find out about it are board members who hold a public trust had a conversation off the books, off the record. What's going on there? Already lost if you've been sued. Let's talk briefly about electronic attendance. I'm sure most of you know about all this. If one or more of you can't be here in person, what do? Can you still go forward with your meeting? Of course you can. If you have enough people, just move forward as normal. If you have to, but at that point you can't have your voice votes. All in favor, say aye. And to protect the public so that everybody can know how the person is voting who's not physically in the room. If you can't make that second point there, if you can't make a quorum with in-person membership, then you can issue a statement of necessity and say, well, we understand. However, our duty to the public in terms of moving forward with our meeting trumps the fact that we don't quite have enough people here. Half the members are by telephone, so you adopt that statement of necessity. See this very broad, expansive language again. That exclusion, by the way, at the bottom there, the act is construed most favorably to the public and is all-encompassing, except where the statute on its face excludes its application. That has to do with the public fist. Violation of the Sunshine Law, and talked before about how that action would then be null and void, as though it never. But the state treasury has been committed to some certain act, state fund. There is that unraveling all of that kind of commitment of public funds could be a worse result for the public than this violation of the Sunshine Law. Nevertheless, in order to get to that point, you got to get sued first. But since this board doesn't have that as part of their charter, all right, let's throw you a bone, and instead of beating up on you, let's make. If you choose to allow the public to participate, say, well, we've got a big issue before us. Not obligated to do that. and certainly implicit in this is the right to have somebody removed from a meeting if they're.
David, just a quick question. Is it a all or nothing situation? As in, if you choose to allow the public to speak, that gives all the members there present the opportunity to come up and speak if they choose, or can you say you can, but not you, and not you, but you can?
Unequal application is not going to be looked at favorably,
Yeah.
but it's your meeting, okay? And so you have the right to control it because, again, you've got X amount of time to get through all of that stuff on you. So you'd be within your right to say, folks, I'm sorry, there's 500 people in the audience. We can only allow each of you to speak for. Total, we're only going to allow 30 minutes for public comment. You can do that.
Box them in as opposed to excluding.
That's right.
Okay.
Yeah, but you can set up a first come, first serve thing, and that's not going to trouble anybody. That's meetings, what is a meeting, what's not a meeting, what you're bound to do if it is a meeting, and the answer is, it's always a meeting. It's always. So the other big part of it we mentioned was going to be notice, and I will sort of compress this part, because again, providing adequate public notice is something that on a day-to-day basis for you, and a lot of it is as I understand it anyway, somewhat automatic. But there are three parts to the notice provision: the contents of the notice, what goes into it, the timing of it, and the location of it. Contents have to reasonably describe the purpose of the meeting or the. At the beginning of the presentation today, I mentioned that agenda is one of the parts of giving notice. Well, yes and no. You have to give adequate public notice, okay? It has been the custom of this board, and my understanding is all of the boards and commissions within the Division of Reg Boards here at the department, to format as the standard, normal way in which they elect to communicate the content. Not required to use an agenda, but that's the way we do it, and there's really not been. But this should also be good news to you. Once the agenda is published, not everything is going to be on the agenda, of course. It can't be, because at the end there's always a section for new business. And by definition, you don't know what the new business is going to be. It's new. So how do you put that on an agenda in a sort of specific way? Well, you can't. Okay, so we know from that logically that there's going to be some deviation. You don't have to twiddle your thumbs until they get there. You can take Part B of the agenda first. Okay. Good news for you, dear board members, is that it's not the Ten Commandments. Once it's been published, it's not graven in stone. Okay, that's published. While we can amend it, we kind of want to stay within that ballpark. Timing of the notice has to be posted sufficiently in advance of the actual meeting to give citizens both the opportunity to become aware of it and the chance to attend it. The most detailed possible agenda, and you publish it 2 hours before. The general rule is somewhere in the 7 to 10 day neighborhood is usually where courts fall down when they have to decide on this. Checked your board's website yesterday, and I think all of your scheduled meetings, regular meetings for the calendar year 20. Location. The usual methods are going to be internet, newspaper, and posting just means staple a flyer up somewhere. With the internet, we publish notice of your meeting on the Department of Commerce and Insurance's website. In addition to that, we post your board's website, the Board of Land Surveyors website. In addition to that, the public can sign up to receive an email blast that wanted to be notified anytime the Land Surveyors Board met, because you're interested in what they do. Okay, they're going to meet in X number of days at this place and time. Bill posting on the day of the meeting.
But you don't, the email blast doesn't. Notify doesn't do
Okay.
the meetings yet. That's not a
I wasn't sure, so maybe it could in the future.
it maybe it could in the future.
Newspaper, you used to hear this newspaper of general. Posting, we do publish post a flyer in the lobby of this building so that nobody can say, well, I found the building, but it's a big building and I couldn't find the right room. Attorney General has talked about this and the adequacy of various outlets for trying to meet the location of notice requirement. So again, you've got to do all parts of the notice. You can't say, well, we published the meeting dates a year in advance, so now we can get by with less on the. Got to do it all. And at last, the very last slide. In a nutshell, folks, the Public Meetings Act is designed to make sure all of your business is conducted in a way that is accessible to the public. It absolutely, both in your individual capacity as a board member and collectively. All of your meetings are meetings under the Sunshine Law and need to have that adequate public notice. Regular meetings, special meetings, emergency meetings. Again, that only exception is going to be where you go into the metaphorical back room with your attorney in order to ask sound legal advice. Excuse me. Lastly, again, if you violate, those acts are void. They're not voidable, and again, that's a little bit of a legal distinction there. Not voidable, in other words, they're okay until somebody sues you and gets it overturned. It doesn't work that way. If you do a bad thing with regard to this, as though it never happened from the get-go. And you know, there at the end I say, well, the best way to protect yourself is to be paranoid. That's probably a little. Certainly, if there's any doubt in your mind, then you know, your best. Also protecting you from you know, having every decision that you've made being torn apart. And endeth the lesson, folks. So if there's any questions, I'll be happy to entertain them at this point, or I can go away.
I have it's been an ongoing question. I'm glad you're here. You did a marvelous presentation. I hope that I absorbed as much as I could. I'm sure I didn't get it all, but I hope to continue to learn. My question is this. We function under Robert's Rules of Order, okay, as probably almost all boards do. And in speaking with the spirit of the publish an agenda, and from time to time, there are things that may arise that we may want to talk about during that agenda, just like you mentioned about new business. It's always been my understanding by Robert's Rules of Order, we can amend that agenda to discuss that. Now, I do understand, and please correct me, this is the most important point I'm going to get an understanding about, that we would be able to discuss items. However, if it was an item that was newly added to the agenda that would require any voting by the board should not do that voting because it was a newly added item until it was properly publicly notified. Did I say that correctly?
I think that's right, and you can get a more authoritative answer to that from. Well, Mr. Chairman, I was the president of my high school student. Cover this. If you come out of the gate and say, there is a piece of new business that is before us at this meeting today, this afternoon. It's not on the agenda because it's new business. Nobody's heard about it before. The public hadn't had a chance to. Okay. Let's just think for a second.
Railroad.
It's going to look like, it's going to have what we call the appearance of impropriety. At a minimum, it's a giant red flag. And,
Right.
and so it's something that we probably ought to avoid. If you take up a piece of new business, you know, there's probably no harm.
I guess it comes down to the ability of the board to be able to discuss items at a meeting with the understanding that if that item affects the public or people that should have been noticed, then we shouldn't take any action on it. I guess that's the best way I know to say it.
Well, I'll jump in. I think your question was a good one, but also very well stated. I agree with what Damon said. I think the bottom line is that you're okay under this scenario because whatever you're doing, you're still doing it in the open, okay? Ultimately, I think our message is, although we want to respect the agenda, make it as detailed as we reasonably can and out as soon as we can, ultimately the agenda serves you. You don't serve the agenda. You know, with that in mind, there's something to be said for wording things a little more generally, and the best example of that, tried and true, is new business. And by definition, new business is new. I think what we're saying is a matter of best practices, and we feel pretty strongly about this. Not necessarily that it's absolutely, positively required by the Sunshine Law and would thus be illegal, but absolutely the best practice, if it's truly new business, talk about it in the open, talk about it as much as you want to, but let's just not make a final decision.
I mean, I think that's the spirit of where we were going with that. It really is. The second thing I would like to ask, and you basically touched on it. We have several occasions throughout the course of a year that as licensees, the three of us are at the same place. You know, whether it be a association meeting, there's a potential for the three of us to potentially be at an examination that this board administers. And I personally feel that we should be there for the potential registrants to see us, maybe even meet with them, you know, shake our hands, greet us, talk to us, that type of thing. I see no problem with that, but I want to make sure that all of us on the board are clear that if we, you know, attend something of that nature, that we're okay if, you know, more than one of us shows up.
It's not so much, and this is sort of what I would what you're talking about when you're there, okay? Shouldn't rise to the level of deliberation. Now, if you whether or not it was discussion or deliberation with regard to board business, then you're better than me, and you know, God bless you. But I wouldn't want to bet myself on it. So I think to the greatest extent that you can steer clear how can I stretch the envelope? This is I find myself walking in a sunny, grassy field, and I want to walk near the edge of the cliff, you know, lest I trip over an anthill or a stiff breeze.
I agree. Ultimately, we're not here, and the Sunshine Law is not here to tell you where to be or where to go or not go, or what opinions to have or what to think. But we are kind of we're not muzzling you because we're saying say whatever you want to in an open setting, but we are trying to redirect those substantive, deliberative conversations. And so, you know, ultimately this is just part of being a board member. It's the rules that you have to go by if you and are, you know, honored to be a board member. I guess it'd be kind of like being a judge. I often feel sorry for judges. I mean, I see a judge every now and again at the restaurant, you know, I know they feel like they can't even barely even say hello. So it's just kind of the way it is.
Yes, sir. Yes, sir, it did. Very, very well. Appreciate that.
Yeah, I think I would just, not to beat the dead
Well, and the uniqueness of all being the same profession and a very small board and belonging to the same similar things and that type of thing, you know, the instance a little more often than if we were a larger board and more diverse and that type of thing.
That makes sense. It's interesting to me. We're going to give this presentation to the accountancy board tomorrow, and I know we're both feeling better. We got one under our belt. Damon did a great job. He gets most all of the credit. Anyway, this will take on an interesting, different context with different boards, with X number of members spread in different directions, sure. But anyway, we appreciate you letting us be here, and we're happy to do it.
Ask one
Yes,
question. When you talked about executive session there, sometimes we as a board probably need to sit and discuss some things, whether we're deliberating or whatever we may be doing. And we don't need everybody else around as we discuss this thing, because some things that shouldn't be gotten out and given to the public and going and spread like wildfire, where the intent was not for it to be that way. How are we to be able to conduct something like that and not be construed as being railroading something in?
Well, we can give our best shot at an answer. Do you have any specific examples in mind? I mean, you don't have to name names, but just so I can get a flavor for
Well,
this.
I guess one of the things maybe in discussing an exam or something that we may be about to give, or the thing that's coming up now is that our exams are going to be given computer-based testing for one of our exams, and the rest of it is still going to be a pen and paper exam, what have you. But we may want to discuss questions on those exams with the fellow that is under contract with us to do these kind of things, where we don't need that information to be overheard in the public, because you don't want to give away your answers to your.
That's a little bit of a sticky wicket. I see where you're coming from. Go ahead, Damon.
Yeah, that's an interesting question. You know, again, what brings me here before you today is risk management. You know, to comply with the law. You know, how comfortable are you with, and the minimum, as we've seen, is a pretty great deal. How comfortable are you with having greater numbers of the public being irritated enough to want to ask, or, you know, send angry complaints, or yes, I don't know anything about what it takes to test or license.
What I detect, and this would be something that you and where you're coming from, it's what I might call kind of a messier topic, a sensitive topic that you would just as soon not kind of brainstorm for God and country to see. Frankly, that in and of itself doesn't trump the Sunshine Law. But if those things come up and trying to be strategic about it, I think you could share that concern with Rob, and perhaps there's a way to properly fashion that as executive session. Interesting question that might come out of your question. I don't know the answer to this. I think if it came up, Rob could look into it. You know, I could foresee something where a specific contractual issue involved specific pricing and other things that at least the vendor might call proprietary or confidential trade secrets, what have you. It's an interesting question to me whether we somehow could go closed, not open, if we were going to go through details like that. It doesn't really fit the model of executive session, but, you know, and it's a discussion to have with Rob.
I just kind of think, and just from the Northcutt opinion is, common sense probably would say, hey, you don't need to let the public in on all of your questions and discuss that in front of the public for anybody to hear, because obviously we're testing applicants to see if they qualify for a license. That was just an example, but,
Well,
you know.
no, and I completely appreciate your question. Putting myself into your shoes, I would look at it the same way. You know, do we really have to air this laundry? It may not be dirty, but air this laundry in public. But I guess, being in the shoes that I am, the lawyer, I will tell you what you're saying is more or less at odds with the broad construction, which is whatever you do, you got to be doing it in the open.
If we're getting down to the point, job interviews, first round job interviews to get put on the vetted.
The exam provider currently is under contract. One of you could meet with the exam proctor, and that discussion would not be a meeting. But if two of you did, then it would be an open meeting. You meeting with one of you meeting a vendor is not an open meeting.
Sam. One member of the board meeting with a vendor.
Off the cuff, I mean, there could be special circumstances, but off the cuff, I would say no, because there's a certain counting game. Two or more of the board getting together, not by chance and not just to discuss the weather, boom, that's a meeting. That doesn't sound like a meeting. Not that we wouldn't want to maybe talk to legal about what we're going to talk about at that meeting.
The board would have to authorize it.
Right.
And I
Yeah,
think
that's true, too. Yeah.
That's
That
the
would be
caveat
discussed
there.
at the board meeting.
You know, if the board is as a whole is going to have to kind of put their imprimatur on that, so that and that's a authorization that's going to have to be made in the context of a public, so that the world knows that, you know, we're sending you, Mr. Northcutt, to go and, you know, have a sit down.
I think that's right, and that's a very important point. Goes to a lot of things that the board would do. There's an agency principle at work there, but like you say, in the open, that was an interesting noise. In the open, the board would deliberate as much as it needed to, then decide or vote to authorize X board member to go and be its authorized agent, and that's the way to button that up. And the beauty of that, of course, is no one could later say that the agent wasn't authorized and thus that act was null, not because of the Sunshine Law, but null for other reasons. Yeah.
When we did the contract for our complaint reviewers, we have 3 complaint reviewers with a contract, and basically all the board was allowed to do was discuss criteria and pass it on to Mr. Herndon, and Mr. Herndon met with the complaint reviewers and passed that on to them. And I don't know that actually, I know in the beginning it did not cover how the board wanted those folks to do their job, basically. And it's gravitated to where they're doing their job now, but it's been arduous getting there, because we had to turn a few things back to them and that type of thing, you know, because of that separation. Where it would have been much easier if they had attended in front of us and we had to talk to them, but maybe that didn't fit with the criteria.
Well, I don't know what all went into that. I mean, another way to skin the cat, as they say, I think, is to have your attorney handle that. Not that you couldn't have a board member separately or in tandem with that handle it. I do think we've done the right analysis in terms of a single board member doing whatever. Does that become an open meeting? No.
No. Mr. Herndon handle it, you're covered. And I think what we're saying here, publicly and openly and on the record, designate one of you to go meet with them or go with Mr. Herndon to meet with them, you're also covered. So long as the public understands. Of yourselves in there, though, then that's a meeting, and that's got to be on the record.
Regrettably, I have to disagree with that because I don't think that it's in the best interest of the board, of the profession, what have you, for just one individual to go in and sit down and talk with a vendor or a contractor, what have you. I think that what I might hear, he might not hear, or he might not hear, or he hears differently as we discuss whatever we're doing. So from that standpoint, I don't think that still it is a, quote, public meeting just because we were discussing that kind of material or whatever we're dealing with. And that's my opinion.
Well, no, I think, I'm glad you said that. We may have glossed over that a little bit. I don't know that you would call it a policy decision, but it's certainly not a legal decision whether you want to commission one and only one person to take on that role. But again, kind of where we started, the Sunshine Law would have required you guys to debate that in the open before you commissioned one and only one of you to go and do that, at which point your ideas make a lot of sense to me. Maybe you would prevail upon the others, no, let's don't do it that way.
And I understand that from that standpoint, that we should have discussed it, but there again, 2 years are better than one, or four are better than two.
Hopefully this discussion, and I have only 4.5 months under my belt here and haven't necessarily worked with you guys real closely. Hopefully this discussion not only educates you, but also may cause you to think about some things that have come up in the past in a way maybe to do things better in the future while obviously complying with the Sunshine Laws. There's different ways to get things done.
See, a different from the engineers, architects. The engineers, architects, when they do a contract for their examinations, it's complete, it's from A to Z. It covers all the examining, okay? Whereas for our board, we do 80% contract with somebody that goes A to Z, but the last 20%, we basically are responsible for with that particular vendor. It's that's sort of a special little animal within itself, and that's the discussion that Mr. Northcutt's bringing up is that I think you get the gist of. We can't sit here and discuss the questions and put them on the internet so everybody knows what all the answers are.
Well, and I see where you're coming from. Rob had mentioned, tell me if I garble it, he does have past experience with another board where, to some extent, as crazy as it sounds, they had to go on the record and discuss some test questions.
It wasn't one of my boards, but that's what I understood happened.
Okay.
I remember that incident.
But again, as Damon has said, one of our primary roles as lawyers is risk management. That is risk avoidance, not letting you fall off cliffs and say, what happened? I wish you had warned me. But at the same time, we are advocates, and I dare say that when these situations come up, if you talk to Rob about it, he can probably figure out a way to make everybody happy. That is, to comply with the Sunshine Law, but not shoot ourselves in the foot strategically or policy-wise.
No, I'm good.
That's what good. We don't want to overstay our welcome, but appreciate it. Good to see you all. And
Thank you, gentlemen, very, very much. Appreciate it.
Thank you, Mr. Chairman. Thank you, board members.
They can take the.
Present tomorrow.
That's it.
I think you're still umbilical here. There you go.
Yes, Yes, ma'am. Turn the TV on. We're gonna take about a 5-minute break here. And we'll reconvene shortly when everybody gets all their electronics found and wound up. I don't know what the guy in two back yonder's got up their sleeve. Nope, I don't. These two fellows were on the agenda. I don't know what their deal is.
I think they're just listening.
That's that girl come down here with the assistant commissioner there. Hey, Donna.
Well, too bad is you cannot discuss anything unless it's in here.
Legitimate, they don't give specifics on question one. They just say, they review the questions. And that's all it says, literally, that's all it says. So the problem comes up with, all right, number. That's where we get caught.
Absolutely. That's just like whenever I used to, whenever I did the, whenever.
Taking time, if he's taking time to come down here, we want to hear what he has to say. Sure do, yeah. We don't want to waste anybody's
Because
time.
they don't tape it anymore, right?
Sure.
Right.
They don't tape the meetings anymore.
Okay.
No.
Yeah, that'd be great. That'd be great to come. That'll be great.
Oh, why not? Yeah, I just,
Yeah, the whole privacy issue of the exam itself
I mean,
is the issue.
you can't afford to.
Has to be.
There has to be some line drawn that says, okay. Yeah, but if they took the bar exam and they did the same type thing.
Protecting the public.
That's protecting.
Jeez. Oh, they get clever now. Yeah, they're gonna trump you in every way they can.
Well, see, NCAAS is doing that also. When you go
Sure.
take the exam now, they provide everything. Over-regulate ourselves. Micromanage. And government is a prime example of that.
Big brother.
Serves a good purpose. It's like unions.
Oh,
Same
sure.
thing as unions. They served a great purpose.
At a point.
On
Yes.
the surface. In the big picture, they serve a great purpose. But when you get underneath and get down to the nitty gritties, well, it's
Yes.
ugly.
Oh.
It's ugly.
Galen, that's why I live in the country. As much as I like this gentleman right here. I mean, there's no way. You know, they run me out.
It ain't country enough. Not country enough for you.
It's like French.
Government services he's getting in return, though. Look at all that.
Of course.
Barney Fife is his new.
Oh, does he?
Better watch out.
Oh, Barney, eh?
Oh, I just got to figure out which way to point that gun. I haven't figured that out yet.
They gonna give you the.
Don't load her to the gun. You can carry it.
Oh, me.
Well, smile, Rob.
It's all good.
Oh, yeah? Cake is.
Yeah, have some. Don't just let it sit there.
Take notes and bring the information.
Oh, yeah, you think that's gonna happen?
No, I know it won't. But yeah, just.
That's exactly.
Oh, this is so brawling. I think y'all called about the Murano, the Nissan Murano. It's 2011, and it's fully loaded. It's got leather seats and heated seats and everything. And it's got 63,000 miles on it, and I'm wanting 63,000, and it's got 5 for it, 23,500. And it's Murano LE, which is the top of the line of the
What
Muranos.
can you do? I mean, you just gotta.
What did you say? No, I just got another one. There's nothing
I
wrong with
wouldn't want
it.
to be that way either. But.
Yeah, it's my
What'd you say,
car,
Storm?
and I just bought another one. Just trying to sell that one. Got leather seats. The seats are heated in the front and the back. It's got a heated. It's got 2 sunroofs, and it's got a one. Still under warranty up to 100,000 miles. Uh-huh.
Your office isn't in the house.
See, when I started my business, my girl.
Okay, it's now 2:07, and we'll reconvene the meeting.
Michael Driver from our legal department is here to talk about the continuing education question you had earlier about the payment to the committee members for their
Okay.
services.
Go ahead, Mr. Driver.
Thank you, board members. Hope you're all having a great day. Appreciate you all letting me come in front of you today. Michael Driver, I'm one of the chief counsels for regulatory boards here. And Ms. Whaley brought me a question I think you all had about the possibility of, I think the first question that was posed to me was charging continuing education vendors, as I understood it, for review. The second question was providing compensation potentially for an advisory committee. And the third question was the ability to, I believe, procure a contract to have a third party perform the review of the applications. In my review of this, it does not appear that the board has the authority to do either of the first two of those, either provide compensation for the committee members or to charge a fee. This board's fees are actually fairly tightly laid out in statute, and there's not any room for interpretation there, where you sometimes can find some. And also, these vendors are not licensees or otherwise regulated by the board as such. As to the third question, though, I'm not aware of anything that would prohibit the board from putting out a request for proposals for someone to perform a review function and then report to the board. I think the board would still have to perform the final approval of any of the continuing education vendors, but I'm not aware of anything that would prohibit the board from, as I said, procuring a contract for someone to perform review on behalf of the board and then present that to you.
Okay. On the first question, if appropriate legislation was crafted that gave the board the authority to charge the vendor for submitting their product for consideration, then the board would have a fee then. Would that not be correct?
Absolutely.
Okay.
Did I answer your questions?
Well, you have, not satisfactorily, but you have answered the question. Just one thing. What happens?
Okay. Mr. Northcutt's question is, how is the expert witness, well, actually the complaint reviewer, which can become an expert witness, how does that work? As I understand it, those individuals were also contracted through the department, and I may let Rob speak to it or whomever.
Well, I think that would work the same way. I do think you could procure a contract to have someone serve in an advisory capacity, which is what I was saying under that third point.
Okay.
I don't think you could just convene an advisory council and provide compensation to them outside of the contracting process, but I do think you could contract them as professional services in the same manner that the expert witness
And that was
complaint
brought
reviewer.
forth with that series of questions from the standpoint of an alternative to item 2, which I pretty well knew when I asked the question probably wasn't going to fly.
Right.
But the third one I felt like had some merit.
Right.
Which the department we would have to basically do the same thing we did for the complaint reviewer, expert witness situation. We would have to the board would have to craft criteria, et cetera. Then the department would do the appropriate advertising, so forth and so on, and selections would be made, and then, it would be agreed on what the compensation would be and those type of things.
That's correct.
Okay.
Is that compensation for our complaint reviewer, expert witness, taken out of our funds that we bring in here then?
Yes, sir, it is.
So then the course reviewer, if we contracted with individuals to do that, that would be the same thing?
Yes, sir. It would be taken out of your revenues that you take in from your licensees.
You see, the reason I ask that, because if that's the case, and these vendors are sending us course after course after course after course, I think, as Tim said, I think we need to have some legislation crafted that would allow us to charge the vendor for the courses that they submit to us, whatever it might be, unless it were the professional organization in state, our own professional organization. If they're going to provide continuing ed, I tend to look at as the organization as doing it as a professional courtesy, let's put it that way. But if we're having outside vendors submit these courses and we can get legislation crafted for a fee to be charged, then that fee, would that stay within this department, within the board, and then I could funnel that to our contract reviewers?
That would depend on the legislation, obviously. I would imagine typically when you're going to charge a fee for that sort of thing, I would imagine that, yes, those fees would typically go into the board's fund. But again, that depends on the specific legislation and what the language of that is.
Now, I only think that way The state is not out anything. The vendor is giving us whatever they're going to give us, and they are then, in turn, their fee is being used as compensation for the reviewer to see is that adequate course, or is that material adequate good courses for continuing ed for the surveyors. So.
Anything? Jay, you have anything for Mr. Driver?
Thank you.
Okay. Thank you very much for taking your time to come down and answering those questions for us. That's very helpful, and we'll keep that information and see where we take it in the future.
I'm happy to be here and appreciate y'all coming in today and letting me speak.
Thank you very much.
Thank y'all.
Okay, I guess the next item on our agenda is to review Colonial States information, and I think, Donna, you've done a little research on that possibly?
I don't know where it's at on your iPads. Let's see.
Figured out how you can tell what page number something is on here, but that's,
At the bottom.
Touch the screen soft once in the middle. At the bottom, the numbers.
On page 75.
okay.
How do you get to it real quick?
It's on page 77. Is that right? Oh, you're right, 75. there it is.
put it in your notebook.
75. You're on 66. That's all, guys. We're not real fast this stuff.
70. Too cheap with the big.
Yeah, it must be.
How you got, Bubba?
Over there.
Voila.
Ran out of ink.
That happens.
Okay, we found it, Don.
We found it.
I have a question on this Colonial States. I mean, what is the reason we want to be members of Colonial States? For just my clarification.
Well, let's see if I can state it in a couple of ways. Number one, the Colonial States organization primarily, to my understanding, represents the colonial states that have meets and bounds type survey work done. So that's number one. And it's a commonality of those states when they have meetings as far as the things that they discuss are more relative to meets and bounds type work than they are relative to public lands.
Public land, yeah.
So we basically have two primary divisions in the United States. We have meets and bounds and public lands. Well, Colonial States embellishes the meets and bounds states.
It is meets and bounds,
And
right?
Tennessee is meets and bounds. Okay, so that's the primary reason. A secondary reason is hopefully at some point in time in the future, this board may have an opportunity to utilize an examination that they provide. And that examination, it's actually two examinations. One examination is an examination that they use to test photogrammetrists who are trying to be licensed surveyors. And the second examination is to test GIS individuals who are to become licensed surveyors. And they have created an item bank for these examinations. They have been approved, particularly for their mapping science exam, which is for photogrammetrists, through the NCEES. So in a sense, they're a sister testing group through NCEES for these other paths to licensure for land surveyors. Understanding that currently we do not have a requirement for photogrammetrist or GIS licensure in the state of Tennessee, but this is a good situation to be involved in to continue to learn more about it and be appraised. And if you are a member of Colonial States, I think the examination fee, and Galen can correct me if I'm incorrect, but I think the examination fee was like $500 for a member to have the exam, the questions for an exam administration, versus if you're a non-member, it's something like $2,500, I think it was, if you were a non-member.
I know it's
So there's some
pretty
merit.
hefty.
Yeah, there's a pretty significant difference between being a member and a non-member. If for any reason you have a necessity to be able to use their mapping science examination, they have what they try to do is they try to have a Colonial States meeting at the annual NCAAS meeting. At the last meeting that Galen and I attended, we attended that Colonial States meeting. It was very informative. Very informative. They also work, Colonial States also does a little bit of work with the CFEDS program, which I know Jay is a licensed CFED and is very familiar with that, which that's a certified federal surveyor, basically. Yeah, that's what CFEDS, the acronym's for. So they do work with that situation some. So they're involved in a variety of things, and like I say, they have meetings that we are able to attend when we're at another meeting, and they do have a regular annual meeting themselves, which is usually, I think the last year was in Maine, I believe is where they said it was.
Yeah.
It was in Maine. It's usually somewhere in the Northeast, because that's primarily where a lot of the members are. So I don't know if that's a very adequate explanation or not, but that's about as good as I know at this point. Looks like you've probably contacted Doyle Allen.
I did, because they don't have a website.
Right.
So I had to get in touch with him to get him, and he sent me this
Okay.
email to me.
Gentlemen that are officers, I'm familiar with all three of them. David Atwell is the current chairman of the board of the examiners in Kentucky. He's a good personal friend. Richard Smith is on the EPS committee that I'm on with the NCAAS. He's from New Jersey, fine man. And of course Doyle, I've known Doyle for many years. He's a former Virginia board member on their Appellate SIPA board there. And he's also the chairman of the board and really the founder of the Colonial States. He sent a little narrative that's probably a little more informative than what I gave. I do know that Virginia, North Carolina, and South Carolina, they're all using Colonial States exams, and a few other states are too. In fact, let's see, wasn't it for photogrammetry? I think the state of Oregon and the state of Washington, I believe, was using it for photogrammetry also. I remember they mentioned that at our last meeting. So it's their work is known very well and very well thought of as far as particularly this mapping science examination that they prepared. So, you know, if we ever get to that point of looking at that, then we certainly have something in place that would be very easy to acquire and administer.
So Tim, are we looking for membership into Colonial states. Is that what we're looking for? Is that what we're asking for today? Is that right?
Yes, that's what we're asking for. We were actually a member 2 or 3 years ago for 1 year, and we didn't continue that. And Doyle had asked Galen and I when we were at the annual convention about membership again, and I said, well, I'll bring it up to the board.
I'll tell you, I didn't realize until you mentioned it that they were the driving force behind the examinations of photogrammetry. I didn't realize that.
Yes, they are.
And of course, with I believe it's on our agenda either today or tomorrow to discuss the possibility of some photogrammetry aspects. I think it'd be to our advantage here to certainly be a member of that. So I would make a motion as such.
I second that.
We have a motion and a second to apply for membership for Colonial States. Is there further discussion? Okay, if not, all's in favor?
Aye.
Opposed? Okay, motion carries. Ms. Donna, if you'll take care of that, get in touch with Mr. Allen and however you have to handle the check and so forth and so on. And we'll try to do a little better job of continuance as we attend these meetings in attendance.
I have to get the commissioner's approval before we can spend any money, so I have to go through all that.
That's fine.
Okay.
We just said we're interested and we
You
know
have
you
our
gotta do
approval.
whatever you gotta do.
Yeah.
Well, we don't know exactly what all that is, so.
I don't either really.
So you
we'll
do what you
figure it
do
out
best.
together.
How's that?
Don't I figure it out?
Okay. Okay. The next item on the agenda may be a little premature. And the reason I say that is, if I remember correctly, in the director's report, Donna, you mentioned that the continuing education chapter was still here in the building? Did I hear that incorrectly?
No, it's still here.
Is,
We're still working on those. Getting them out.
okay, I guess my question would be, if the professional conduct made it to the AG, how come the continuing education didn't? Maybe.
Good question.
If the continuing education, or if the professional conduct chapter is already at the AG's office for review and consideration, my question would be, how come the continuing education chapter didn't make it?
Well, I simply haven't gotten it finished. Three different sessions that we've had, and I have got one up. I wanted to have both of them up by the time of this meeting, but I just simply haven't.
That's fine. No, that's fine. It's just, I like to ask a question and get some type of answer, so at least I know some direction.
Yeah.
I expect to get it up there before the next couple of weeks, for sure.
Okay.
Because I wanted these two chapters to become effective at approximately the same time.
Right. And is it your anticipation that the AG shouldn't have any issue with them as written, or?
I always say that.
Well, I understand that.
But they'll probably send it back at least once. They've sent back the engineer rules twice. After the AG returns them, they'll have to sit up at the Secretary of State for 90 days. Operations Committee to explain the rules. So if you want to pick a volunteer to go with me to explain these rules, that would be helpful. All of you want to go.
Volunteer, Jay, that's fine.
I'll go. Just let me know.
Jay's our legislative person.
If two of us show up, then what's going to happen?
Wait a minute, hold on.
No, we can't do that.
Well,
Don't
the
do that.
Government Operations Committee is already a noticed meeting.
Oh, okay.
There you
so-
go.
You will
Caleb.
be on the agenda, so.
So you can get a go to that one.
that.
Why not?
That'll work.
Okay.
If that's the case, Tim, I think you started alluding to it a little bit earlier. We might be jumping the boat here a little bit in terms of a whole lot of progress that we can make in regard to the structure and format of standards of practice and ethics. And Is that right, continuing education? I mean,
That's kind of where I was leaning
don't know if
towards,
we can make a-
saying we was jumping the boat a little bit, but at the same token, if we want to discuss it some, we could.
certainly can, or we can move it to April. Is that the next meeting? April? Sounds like it'll make
Whatever
more
the,
progress.
whatever the board's pleasure, as far as I'm concerned.
Well, why don't we just touch on it a little bit? I assume that, of course, I had gotten some research here that Donna had provided on some other states around us that offer, or I should say mandate, either standards of practice or ethics or both. And certainly, just from what she found right there, it seems pretty prominent in the adjoining states, which certainly led to why we agreed to include it in the rules change. But it looked to me like in terms of structure, if that's really what we're going to be talking about, structure, I assume what we want to talk about maybe is quantify. How many PDHs are we talking in each of the others?
I think we actually did that.
I think we did that as well, yeah.
We did that as well. The PDHs were 2 and 2, ethics and 2 for standards, as I recall.
Yep.
So I think we have that part. One thing I'll throw out, 2 of the adjoining states I'm licensed in and have to go to these particular seminars, Georgia and also Kentucky. Now, both of those states, one thing that they do from a board standpoint is it's mandatory that a board member be at that particular seminar. Yes. In other words, that seminar is not given in either state unless a board member is in attendance. Now, I don't know that we necessarily want to do that or we don't want to do that, but I find that unique in talking with the chairman of the Kentucky board, Mr. Atwell. It was something that when they crafted that and put it in, that was something that they were very emphatic about. Because they said, people can cheat, as far as putting somebody's name on the list or whatever. Sure. And they want to make sure that they're there. And Kentucky, different than Georgia, Kentucky actually reads their standards of practice from the start to the finish. It is a very dull. It is a very dull seminar. I certainly don't suggest that.
Yeah, I was going to say, please don't.
But and Georgia's is much more open discussion related and things of that nature, particularly on the ethics side, more so than on the standards side, obviously for obvious reasons. But that was kind of some of the things that I wanted to think about besides how we do this, because I'm hoping that the board will be able to give reasonably specific direction to whoever the vendor may be that presents it, whether it be just an individual licensee or whether it be a Struckman Thorpe or Red Vector, whoever it may be.
Well, that could be formulated through instruction to the advisory committee, could it not? Saying that, vendors that come
Yes.
in and request to be able to teach these 2 specific courses
Yes.
must follow a certain outline, and
Right.
we could give that outline.
In Kentucky, you'll find, for example, there's only last year, if I'm not incorrect, there was only 2 vendors, Radmanovich and can't think of the other boy's name right now. There was only 2, and I know I heard Jimmy mention Kentucky Convention. They'll probably offer that up there.
Sure will, yeah. On Saturday.
Yeah. I don't know if I'm gonna make it to Kentucky yet or not.
I was gonna offer to the board, I'll actually be attending the Mississippi conference next week, and then I'll, of course, be at the Kentucky conference, and just
We certainly appreciate that.
other states can conduct theirs.
Yeah.
More than happy to do that.
As you see, we're kind of in the infancy of this since it's just proposed in the proposed CE stuff, and the CE stuff hadn't been approved yet. And hearing what Rob tells me, we're probably 120 days out right now. Yeah.
Personally, I think this would be a great venue to stir up some attendance.
Again, that's why Kentucky sends a board member, and Georgia does too, to make sure that that basic structure is followed. Board member has to verify the attendance too, yeah. Whereas now, the way we do our PDHs now, the list is just simply submitted and sent in. Our is just simply whoever the provider is, period. Whoever shows up on the list, that's it. Got a buddy or two and he wants to put them on there and they didn't show, that's his business, Other discussion about that at the moment, and what we'll do is, we'll do what you said, Jay, we'll just table that to April. And April, we'll know more about where everything stands, and we can move forward with that then.
Every time I submit rules to the AG, I put time sensitive. So hopefully they will along expeditiously on it.
Well, they're not only dealing with commerce and insurance, they're dealing with other things too, aren't they?
Well, I've got 5 projects that they're sort of dealing with right now just for me. Lots of me's in the state.
I was gonna say, there's a whole bunch of me's in there, because we've seen, 4 more here today?
Yeah, yeah.
Y'all cloning or something out there, ain't you?
Just what I need.
Mr. Lingerfeld?
Yes, ma'am.
Just so that you're not operating under.
That to me too, but I call them. After a few weeks, and I understand they're busy. Of course they're busy, but this is the business of government, and we kind of need it done.
Well,
Put it like that, but
well, everybody works hard on it, obviously, and you get right down to the point, and you get excited once you get something formulated, and then you're ready to implement, and it just takes a while.
it's heavy lifting at every stage.
Yeah.
I just didn't want you to get to April and be.
After going through the standards of practice situation that we went through when I first started on the board, I don't get in too big a hurry. I just like to know, just if somebody just give me an answer, it's right where it was last time or whatever the answer is, because I know it's going to take time.
Oh, and I know it's not relevant to y'all, but in the intervening period since we had the meeting, one of my boards has been sued twice, which was sort of something you had to kind of jump on right away. And the holidays and all that kind of stuff. It's just hadn't gone as quickly as I was truly hoping it to do, because we've waited so long just to get to the hearing. I mean, it was so long that we did one project and then started a whole other project that caught up with the second project, and we had the hearings on the same day. That's a long time.
It is a long time. It is a long time. I'm going to get out of order just a minute. Donna, do you know what volume of applications we have tomorrow?
There's probably 45 or 50.
5 or 50?
Yeah.
Okay. Flavor of category they're in? Are there more of one than another?
There's some TS, mostly TS.
Okay, that being said, and it being 2:37, if the board is of so mind, we may want to expand into a little bit of the business of tomorrow. Sure. To take care of a few items. Seeing as listed times are subject to change, that's what it says. So the next item on our agenda this afternoon is discuss possible licensing of photogrammetrists. I think that the young lady that was here earlier pretty well pointed us on that direction a little bit, on that path, unless I misunderstood her greatly. I think that we've got the ability to discuss it, but we have to pass the baton to the association to look about driving any legislation. So, you know, I just want to discuss it a little bit. I will tell you that one statement I will make is that NCAAS has specific language for basically creating licensure for photogrammetrists under the model laws and rules for surveyors. So in other words, they have a roadmap, is basically what I'm saying. And then with that roadmap, it's pretty easy to follow from that point. Should, you know, we find some favor in that direction and maybe, you know, look to the association to try to help us legislatively with it. Also the same, NCAAS has yet to determine a roadmap for GIS, but North Carolina and South Carolina have. So there's a good roadmap there. And obviously, when I speak to the roadmap, part of that language is relative to folks that are existing, about how they can be managed to get a license, basically grandfathered, because you've got to do that step to get up to speed before you can exam and so forth. We need to have any kind of vote on it, but it would be good if we had kind of an ideal if we thought that may be a good avenue. My whole premise in discussing this is to improve and expand avenues for individuals their licensing criteria and become licensed. It's to expand the possible areas that they can be in public service to the public. And we have folks in these areas, and if they were licensed surveyors, then as Rob said earlier, currently we don't regulate them, but we'd have an opportunity to regulate them, and that would make that a stronger profession, as other adjoining states have done.
Sure. My experience with photogrammetry in terms of you know, basically subcontracting photogrammetry firms to work with me, or the firm that I'm engaged with, you know, typically they have credentials already. And it doesn't mean that I understand the credentials, but you know, usually a CP, a certified photogrammetrist, is what I'm assuming that is. Are you aware of who that certification is from? Obviously, it's not from the state of Tennessee, as an RLS would be, but is that an organization of some sort, a professional organization? So it's an association or organization?
Yeah, it's their association. It's their national association. It's an acronym. It's a certificate program, basically.
Yeah, that's right.
In the other states like North Carolina, South Carolina, the ones that you mentioned that do regulate, photogrammetry already, when they apply for licensure, if I remember South Carolina correctly, you are specifically applying for licensure as a photogrammetrist. And here's where I'm asking the question: when they're licensed as a photogrammetrist, is that also giving them licensure as a surveyor? Are they on equal bounds? Are they two separate bounds? Or are they completely independent bounds?
There's two separate ways of licensing photogrammetrists. One method is licensed as a photogrammetrist,
completely independent of everything else.
Right. Which that one I think they call a photogrammetric surveyor.
Okay.
I think that's right. And then the other is being licensed as a surveyor with a photogrammetrist specialty, basically. Certificate, basically.
Is that the way South Carolina is structured? I'm trying to remember.
I don't think I have my South Carolina law with me today.
I don't have it with me either. Which, well, I guess I'm curious to ask then, which ones of these are you, kind of geared toward aiming at here in terms of discussion that maybe would benefit Tennessee?
I think the photogrammetric surveyor benefits Tennessee the best. In other words, it just doesn't open the door for them. They do control, for example, for their work. So we regulate GPS, and their control work is interrelated to boundary per se. So we already regulate that. So we're kind of in their domain partially as it stands right now. So that's why I was looking about if we get them, licensed, then we could regulate the whole thing that they do.
Sure, sure.
And it, with both photogrammetry and GIS, it expands that horizons where these young people getting a BS degree and getting their license, it expands the horizon where they have opportunities for other jobs.
Absolutely.
Because most every city and county now, in some form or fashion, has some type of GIS. And as we all know, there's a huge problem with that how that GIS is managed and how all these layers and metadata and how all that stuff's put together, and we have problems with it every single day. I do. I'm sure you guys do too. Because you're trying to use survey data for somebody that doesn't understand it. And, and directly it harms the public. Because it's misrepresentation of information. How many times has somebody called you and said, I got this map here from the county and my line runs through the middle of my neighbor's house. It's just because it's mapped wrong and they had the proper information. So, the public is not being served in that manner.
Sure.
So, but that's why I looked at two of those areas, because I think it's inherent on this board that we also look at things that are associated and relevant to what we do that will help the profession and also continue to protect the public in a better manner.
That's paramount.
So that's where that's at. So, okay. Well, let's go ahead and move on then into a couple of things for tomorrow. I'm going to jump around a little bit on tomorrow's. Okay. Schedule time and agenda for April 2014 meeting with the Engineer Committee.
I talked to John about that.
Yes, ma'am.
He said April the 9th.
Okay.
Wednesday, April the 9th at 1 o'clock.
He wants to meet on Wednesday.
That's when the committee meets.
Okay. So April the 9th, so we'll have a 3-day meeting then. April 9th at 1 p.m. Okay. One item I know that we'll need to probably talk about is some of the pre-planning for the NCAAS Southern Zone meeting that'll be held in Nashville in 2016. Is that correct, Galen?
I think 16 is what they said.
Yeah. Our board and the engineers board will be hosting that here in Nashville. So, and there's quite a bit of work involved in that, so we need to get going on that a little bit. So that'll be one very important topic. And any other topics anybody else may have we want to discuss, I don't know what they might want to discuss. We've not had this meeting now, and I guess it's been 2 years, hasn't it, Donna?
I was trying to think. It's been a couple.
Remember the last time Jackie was on the board?
Yeah.
Because we had it down here in this conference room at the other end of this building. You've been here, what, 2 years, haven't you?
2 years, yeah.
Yeah, so it's been at least 2 years, last time we had it. Then we had it one time,
We were in that building when we had it.
we had it on the other building up there in the top floor up there where we met, third floor, where we met sometimes for our meetings.
Yeah.
Yeah, we had it up there. It's, for Jay's benefit, the engineering board has an engineering committee, and usually that's who we meet with, is the engineering committee, unless some of the other engineers have already arrived or whatever. So I think the committee's 3, isn't that right, Rob?
3 voting engineers and 3 non-voting engineers, so
Okay.
there's a total of 6. 6 individuals.
Depends on which ones are there. So generally they may come here and meet, or wherever, we'll have a place to meet. And we just meet, and it's
I think
very,
they're in this big room over here, but I'm not
Okay.
sure. I'll double
Okay.
check on that.
it's a very cordial meeting. And we discuss pretty much anything, we need to discuss. Obviously, that's one important item. But we've been I think the last time we were both working on rules of professional conduct, I think it was. So we interacted about rules of professional conduct. And one thing that we've tried to do, having the luxury of Rob being their attorney like he's our attorney, is we've tried to make some of our language in some of these areas as uniform as possible, because, you know, they get theirs approved, we'll get ours approved because the AG's seen the same thing before, instead of reinventing the wheel. So
One other thing that, not just to interject, is that because we have done that, and we model our things in law after that, so has the engineers, which makes
and I think we get away from that old antagonistic relationship. It's a much better, more professional relationship now than it has been. And so I hope that one of these days there'll be other issues we'll tackle, and I hope that our professionalism and so forth will help us when we tackle some of those issues with them. Alrighty, so April the 9th at 1 p.m. If you have any other items of things that you might like to discuss with the Engineers Committee, let's just get them sent in to Donna, and she can put it together and get with John and see where we're at. I don't think we have any specific timeline of that meeting, do we? Whether it's an hour or 2 hours, or I think it was an hour, wasn't it? Wasn't the last time an hour, Rob? We met.
That's the time when the engineers go over engineer applications and all that. But I think our time together was probably about an hour.
I think it was about an hour.
I remember we talked about electronic seals and stuff like
Right.
that. Because those are similar problems.
right, we did.
I remember. Might have been an hour, might have been a little less, but it's close.
It was about an hour, yeah. Right. That's, see me, most, the other two that I've attended, I think that's about what it's been, about an hour. About an hour. So like I say, if you come up with anything that you might want to discuss in particular, just shoot Don an email, and she can run it by John, and maybe he'll do the same thing and let us know whatever they might have on their mind. You know.
That's going to be a board meeting for them, but just a committee meeting for
Well,
the
their
engineer.
board meeting is Thursday and Friday. So they'll be
There-
coming in Wednesday
It'll be a
anyway.
board meeting when they're at the engineer committee meeting.
Yeah, I know. I gotta put all that on the website and all that stuff.
Meeting is a meeting. I learned that today.
For the engineers, there's only 3 out of 9 voting members there, but they have to notice it too.
So they don't have to call theirs a meeting because it's, or they don't have to be public notice because,
They do. They just don't have it videotaped and all that. They
okay.
just take minutes. Make recommendations that they take back to the full board.
so the 3 non-voting members, they generally don't stay for the next 2 days' meetings or whatever, or?
There.
Oh, they're there, okay. They
They're
just
just-
don't vote.
That's right.
Oh, okay.
They can't vote on motions, and if we had a formal hearing, they would have to be in the audience. They can't vote. Handy for reviewing cases and stuff, though, because they can't vote anyway.
Okay.
Had to contract ours.
Right. Okay, real good. Okay, next item, I think Jay had requested this item here, is discuss relationship of GPS RTK to boundary standards as set forth in the standards of practice.
I did, thank you for letting me discuss that. And again, this is just discussion here today, and I just kind of want to bring it out in its infancy, because that's what it is, in its infancy. And I will be looking, hopefully I can get Jimmy and Leonard to kind of chime in with their personal opinions on this as well. But this was brought forth, an issue that was brought forth from surveyors down in southwest Tennessee in the Shelby County area, and I've had multiple surveyors ask me this question. And the question goes something like this. Of course, what with GPS becoming pretty much, almost in a sense, a standard tool in most everyone's surveyor's toolbox these days, it seems that way. Certainly they're using that particular tool to perform in their surveys, whether it be a topographic or a boundary or whatever kind of survey. But But more specifically, in a boundary survey, here's a standard situation that develops, and they're wondering how it applies to the minimum standards as they're written and filed today. And here's the situation: is using an RTK receiver, whether they set up their own base station or perhaps they have a network type subscription base station of some sort. Surveyor A may go out there, recover some field evidence of boundary corners of some sort, and take literally one RTK GPS shot on a boundary corner, or several pins of some sort, or T-posts or axles or whatever he finds, and he holds that to his survey, and he signs and stamps his survey, and on his certification he's putting in there the certification that's regulated to be, with a closure value, et cetera, et cetera. But in maybe in reality, but in theory, there is no real mathematical closure behind a single RTK GPS shot. And so some surveyors will bring at the point, the reason that some surveyors are questioning this, number one is are they in violation by doing so, even though you won't see it on the plat anywhere about where or how they discovered or shot in this corner, other than the certification. But some surveyors are saying, look, I'm trying to follow the law and the regulation. The regulations say I have to run a traverse to a certain closure, and I'm doing that. But my competition is running out there with an RTK rover, pop, and jumps back in the truck, and he calls it good. And he's signing and stamping and to the same certifications. So the question's coming about with RTK GPS receivers being more and more commonplace in the truck of every surveyor out there, and it is, how or should this board evolve to how the technology is changing for surveyors? I'm not asking the board here to say are they in violation of the way they're surveying. That's for other issues. But does the board need to look at that situation, or how can it fix the situation in terms of regulation, in terms of either they can or they can't use that particular tool in that methodology towards the signing and stamping of a boundary survey? That's where I'm at. So I just wanted to open that up for discussion right now. Certainly not looking for any votes of any kind, or whether it's even a valid issue to be discussed. I'm certainly looking for y'all's opinion on that. You may or may not have that technology available to you. You may or may not survey that way. That's not what I'm asking. But is that a valid concern? Is that something that perhaps this board needs to look at in terms of regulating? Or is that, possibly if it's discovered that a surveyor is doing that, is that in violation? Really, obviously, that's for the board to determine, but I wondered what y'all's opinion on. Do you understand the process of what's going on there, the way these surveyors are running out with RTKs and just taking single shots on a what they think is a boundary corner, and then on their plat they put the certification, because that's what they're supposed to put, the certification, even though a real traverse and a real closure was never calculated.
Well, they do have to put on the plat the type of equipment that was used. I mean, that's in the static or RTK, and if it was RTK, whether it was a base or it was a network situation where they subscribe. That way sometimes, or
Most of what I use my GPS for, at least in the past several years, especially for boundaries, just been establishing control, bearing, basis and bearings, that nature. So most of the time, I'm shooting them in and running closed traverse.
Well, let me say this, Jay, for what it's worth. Back when we discussed the standards of practice and looked at accuracies that were required, category A or 1, 2, and 3, whatever. When we looked at those, one of the issues that we had was we wanted to increase those. Okay, in other words, as you well know, the bottom is still 1 and 5, and the top's 1 and 10. Well, virtually anybody can take a total station and a prism pole and well exceed those with slight care. not high care. But the problem was, we could not and correct me if I'm wrong, Rob, but we could not craft standards that would basically create a hardship on a surveyor in the mountains up here someplace or wherever that only had a transit and a chain. In other words, the standards had to still be somewhat attainable by whatever equipment and methodology that any licensee may be using throughout the state. So we were sort of hemstruck, I guess you'd say, whatever that word is, about increasing those. So we were not able to really increase those. And when we got to GPS, there was a tone in the room on that day when we got to GPS that they didn't even want GPS regulations. Well, basically, the board took on the position that if we don't have GPS regulations, then we can't regulate our registrant who is using it. So we had to have some GPS regulations. So what you see in these standards is basically what came out of that time, out of some level of necessity. Now, your question has been asked to me several times. And as Leonard aptly said, we have some criteria for what's known as geodetic surveys in our standards of practice. Unfortunately, it's my opinion, and only my opinion, that by the standards of practice that were approved, the utilization of GPS, whether it be static or RTK, must adhere to what the current standards for the surveys that we have, 1 in 5, 1 in 75, and 1 in 10,000. Okay, which, as you well know, it should exceed that, with certain exceptions on RTK in certain situations. That it could be that or less even, depending on, if you're floating or whatever. Unfortunately, that's the set of shoes we're wearing right now, is that. However, in the section of standards of practice that stipulates remote sensing surveys, it does say that for RTK surveys, the board must the surveyor must use the current GPS standards as set by the board. So I think that for both static and RTK, I think that opens it up. The only thing we have done, and this was done prior to you being on the board, is we simply adopted the FGCS 84 is all we have done, because that's sort of the federal model that's out there. And it's fine, that's fine. But I think that to get an answer to your question and where this board and how we should function in this state needs to be, I think we need to craft some additional language that addresses this very situation, so that the registrant is not calling you or Galen or me or whoever because they don't know. I think we owe it to them to craft something that explains it to them what the board really expects. And I think that can, because we have this standard, I think that we now can create, based on factual information, create a standard that's different than what our 1 in 5, 75, and 1 in 10 is, because of utilizing this equipment or any combination between equipments, as you mentioned earlier. So I think that's where we're at, and unless Rob corrects me, I think we can do that, and I think that's something we should do, and we could do it. I guess, Rob, is it fair to say that the way that that's worded in the standards of practice, that would be more or less, would it be a board policy, or would it just be a board standard?
Where's the current standard now?
It's on page 9 in the standards of practice under remote sensing surveys.
Yeah, see, it says static GPS surveys, real-time kinematic. Use the current GPS standards as set by the board, but what are the current GPS standards?
The only standards that, to my knowledge, that this board has issued via the website to the registrants is FGCS 84. which speaks to a whole lot of things, but it does not clearly address this question.
Does not.
We gotta figure out what standards we want to establish then, and
That's what I'm saying. Will what we be establishing is a standard, or will be establishing a policy? Because we left that open at that time, again, going back to being able to have something that we could put our arms around to regulate, but we left it open.
be a standard. It can't be a policy because we can't enforce a policy.
Okay. Now, if we make it a standard, is that just simply a standard we publish on our website? Or is that a standard that we need to, what's that word you use, promulgate through the rules or whatever?
Promulgate,
Yeah,
yeah.
promulgate, whatever it is.
It probably needs to be in the rules, yeah, to enforce it.
Okay.
We need, and I remember that we did set that out sort of open-ended so we could come back to it.
But the most important thing, Jay, is I wanted to kind of get you the history as to why that we're sort of not where we need to be just yet of getting there. And then now, now we can get a hold of it.
We had this, when we updated these rules in 2010, they were already 20 years old.
Yeah.
And there was no mention of GPS in it at all. And of course, everybody was using it. We just didn't have any rules that even mentioned that standard of practice. So we're a lot closer than we were.
And we sort of got our foot in the door, but we didn't get all the way in just yet. So I think your point is very well taken, and I think we need to somehow or another craft some type of standard that we could probably, send through whatever the process is.
Okay. Again, I just wanted to bring it up for discussion to see kind of where the board situation was currently and where we can take it, and I think I've answered that, so that's good.
Yes, sir.
Mr. Lingerfeld, my attendance at the rulemaking hearing, of course, was my first attendance at any Board of Examiners meeting, rulemaking hearing, anything like that. And I learned rather quickly that TAPS got in on the tail end through our own hesitation, and I guess I probably shouldn't use the word apathy, but we kind of just were a little lazy on that. Getting in and trying to get a lot of changes done at the tail end after the board had put in so much work. Is this something that maybe the TAPS could get in on the front end to help with this, and charge our standard practice committee to get on the ball and help be on the front end of this?
Yes. Yes.
Yeah, absolutely.
Practitioners are the ones that have to live with it.
Exactly.
Yeah, we certainly want TAPS input.
Okay.
Because I know you have a diverse group from all over the state that use GPS in all different forms and fashions, and I would think that they would be able to have some very valuable input.
Okay. Well, thank you. If it's okay with the board, I'll charge our standards of practice committee with starting to assemble some information and report back to you at your April meeting.
Great. We'd love to have that. We appreciate that very much. Okay, let's see. Let's go to review language in 62-18-109 concerning PS exam being converted to CBT in 2015. I would say that 2015 has now been moved at least to 2016 from the last EPS meeting. So the PS is not as immediate upon us, but at the same token, if there's something we could do to simply clean that up, it may be a good thing to get it cleaned up. Let's see let me get to that section. 109. Yeah. I don't have a page number on these. Did you put that on the thing, Don, on the little iPad?
Yep, it's a separate book though.
Page 6 in the book.
I'm here.
And then in the top left-hand side, there's a title library.
With it. 109. Yeah, actually the FS is the one that mentions the 8 hours, Rob.
Put that in the legislative wish list
Yeah.
last year to have that removed and make it into the package.
Make it, huh? I guess we need to wish it again.
Matter of fact, I think I've put it on there twice to remove it because of the computer-based testing. Written exam can stay, it just needs to take 8 hour out.
So computer exam is considered a written exam?
Anything
Okay.
that's not spoken or oral is a written exam.
Okay. It needs to be removed from 3 places, basically.
Yes, all 3, category A, B, and C.
So that's still in your legislative wish list? Okay.
Would this be something TAPS could run to get rid of?
Pardon me?
Would this be something TAPS could run through to get rid of?
Possibly.
Housekeeping matter and our exam anymore. Not for fundamentals anyway.
I don't see what I'm looking for. Yes, sir.
That computer-based testing, regardless, the maximum allowable time for a person to take it is 8 hours regardless, right? I mean, whether it's on a computer or it's paper, it's still the maximum time allotted to answer the questions at 8 hours.
Well, the computer's now 6 hours.
Oh, okay. All right.
Yeah, and having the time limit removed would make this statute apply no matter how long it
Okay,
is.
all right, just,
I wish they hadn't have put 8 hour on there. For engineers, they specifically mention NCAAS.
Right.
It's in the statute.
And that's what we were trying to do, is get more parallel with that.
It's not heavily implied because NCAAS was an 8 hour written exam selected by the board, of which there's probably just one.
Okay. All righty, so that item will go back on the legislative wish list then. And is that something you'll be submitting again soon, or have already submitted, or?
Well, they usually ask us about sometime before August of every year to submit our list for the next session, so, and they're in session now, so.
Okay.
It'll be,
It's already been canned for this session, basically?
Yep,
Okay.
I submitted it for this session and it didn't make it. I think I submitted it last session and it didn't make it. Very few, I think we're allowed 5 bills for the whole department, and there's 23 boards in our department, and there's 5 other departments or 4 other departments in this department. So a lot of shoving to get your bill in. Division of Insurance is part of this department, and they've had some activity this year. And competition.
Okay. Does anyone else have any other items they wish to discuss today?
Possible, but nobody's asked us to suggest an amendment. One about the 10-year thing is this statute.
That statute's applying to this specific section.
Yes, that statute is open in legislation right now. I don't know if anybody would be interested of amending the bill to take that out.
Probably opposed to.
Yeah, we're opposed to the bill right now, so.
Okay.
It would be nice if somebody asked us, so by the way, could you take the 8-hour out?
Okay, Rob, one thing we have on here for tomorrow, start review of Chapter 0820-1 for updating. That is the rules for the Board of Examiners, correct?
I think you have a paper that's not on your iPad. We provided a hard copy so you'd have something to write on.
I don't see it. Do you have them, Donna? How about we just let Donna give those to us, and then we can start working on it between now and our next meeting to see where we have concerns. We can start each one of us can redline it on our own, and because it's only really 3 pages.
One
or
thing
4.
I've already done that you'll see is I've added a new rule that has to do with licensing for military spouses. The General Assembly has told us that we have to do that, so we're doing it. And that's just the proposed language, so feel free to, do a hatchet job on it if you want. It has to be in there.
This is sort of boilerplate language for things that are going through the state.
It's lifted from some other boards, but I tried to make it as specific as possible to our board, but please feel free to edit.
I'm going to ask the hard question right up front, and I know the answer, I think. Anything that deals with money is probably most difficult to change.
Yes.
Okay.
Didn't know the answer.
Thought I did. Just we really have one thing in our licensing law that I find quite confusing, is if you don't turn your continuing education in, but you pay your fee, you're not licensed. But if you turn your continuing education in, and you don't pay your fee, you're still licensed, and you pay a late fee based on whenever you send your fee in. That's very contradictory.
My opinion is if you expire and you have not met all minimum requirements, your license is not active.
I agree with you, but I think the way that reads, I think that it reads the way that I stated it, I think. Because, I mean, it's a two-part renewal. Your fee is one part and your continuing education is the second part. And they both need to be in at the same time in order for you to be able to be licensed.
All minimum requirements.
But if you're late with your money, we have a late fee of $20 a month, I think it is, if I'm not badly mistaken. So you can get your continuing education in, but be late with your money, up to a year.
Well, you're invalid after you expire. And by the time you get around to submitting your fee plus the penalty for being late, at that point, you're active again.
But are you actively licensed
No. You have a license.
at the time that your license expires?
No.
You haven't paid, in other words, the deadline comes, you have not paid your fee.
Right.
Right then and there, your license is expired.
That's correct.
But you can regain regain the validity of your license 30 days later if you pay an extra fee.
That's correct. That's
You
correct.
pay your fee plus the late penalty.
And see, that's something that, the reason I bring that up, here's the reason I bring it up. That's something that this board, in our first meeting of the year, should actually do. I think we should have a director's report on that from Donna that says John Doe has not paid her fee, his or her fee, or John Doe has not complied with the continuing education regulations. And those people, in my opinion, should be notified that they're not licensed.
If their license is.
Okay, I just want to make sure, because, I mean, because just what Jay said, because that's what it is. They're not licensed.
Their license is invalid.
And I told them that if they call in and they say, well, I paid my renewal fee online, okay. Requirement.
Right.
And I'll tell them your license is expired till we get all requirements, and all requirements are
I
met.
think that would be a good point to make at roundtable.
I think that's a good sign that we didn't know that they do that, because that means that we've paid our dues and we've done our continuing education. I'm glad that I didn't know you do that already.
Right.
If you don't hear from us, you're good.
Okay, that's good. I like it that way.
Donna and I sent out
Off your duff and get it in, Dan.
I did that again yesterday.
How are the renewals from the standpoint of people not renewing?
I think we've got about
50 that did not renew? 150 that did not
not
renew?
renewed, finished their, either have not paid their fee or done their hours.
Well, the reason I asked that was because I noticed in the director's report,
Some of them have chosen not to renew.
I noticed in the director's report that our numbers on active were just slightly over 1,000.
Because,
Because they've been over 1,100.
yeah, because they're not all renewed yet, if they're gonna renew.
Is that common? Is that standard for, here we are a month into it, that is standard, okay.
Yeah, the last couple of years, it's been a pretty high number. Or the last couple renewals, it's been a pretty high number. Yeah, we had a big, long list, I think, right after you first come on the board, if you remember.
Yeah.
She gave us a big old, long list. Yeah.
I remember that.
Yeah.
See if there's anybody out there that recognizes.
When they send out a notice, is that notice, does that say their license has expired or is no longer valid?
They're expired right now.
Yeah. For any of those that have not renewed, they're expired.
Okay.
just for perspective, we had just had that renewal for land surveyors. The geology board, all the geologists expired February 1st. And they down to 100, I think it was 184 simple and easy for our
Even in the
licensing
emails, we
process.
say, if you want to pay your money online, click here.
here,
All you
yeah.
do is just click and go.
We're making it as easy on the licensees as possible, and for their CEO, allowing them to email it in, or fax it in, or mail it in, Eventually, you'll be able to upload information through the state website.
The numbers change dramatically, every renewal. You know, last time we attributed to the economy, the last renewal in 11 for 12.
Really, there is no other enforcement other than late penalty or just your license is expired, and that's it. They let it go.
Yeah, and if they're
Unless
still
they,
practicing, and we
unless
tell
they
them, if you're
use that
practicing.
license, then there's enforcement.
Yeah, we tell them if you're practicing right now or your license is expired, that's a no-no.
You're in violation.
And you have a record of that gap. In other words, for example, if you're supposed to renew the end of December, and I didn't renew until the 1st of March, you have knowledge of that gap of time.
Yeah, our RBS system will tell us when they renew.
Yeah, and a lot of these folks are out of practicing in Tennessee right now, and I'll get it to you sometime, yeah. Will eventually catch up, but some of them I remember a phone call recently from some guy in Alaska. He's like, yeah, I got it. Yeah, it was
Like he's not gonna be here tomorrow.
you're right, but he's not gonna be in Tennessee right now, you know.
At what point is there just, I mean, even if you did send your money in now,
They have a year.
1 year, okay.
Yeah.
If they can, renew, if they send their money in December 30th of the 2014, and they're continuing.
Late fees and all that, they're good to go.
And generally, unless I'm not here, so, yeah,
Okay. Does anyone else have any other business for the day?
Tomorrow's all applications, is that right?
Yep.
45, huh?
Yep. Okay. If there's no further business, I'll have a motion to adjourn.
So moved.
Second?
I'll second it.
Okay, those in favor? Okey dokey. Thank you very much. We had a very productive meeting today.
Busy. Yeah.
Here's our book.
Yes. First one I've used, I had an iPad.
I want to recharge iPads tonight.
That's a step up from what Chris had, my buddy Chris had.
Chris?
Yes, sir.